Your Lordship,
Must have been
in
settled.
fact, the file could not be traceable.
No,
Your
only,
Lordship,
only issue was whether intelligence officer without the gazette notification has the whole
in fact,
state
prior to-
jurisdiction to assess.
Okay.
It is
No,
true.
what is
but,
this?
the
Which matter? Tribunal. Second appeal.
not second appeal order is challenged by way of repetition
Hmm.
by the revenue. Saying that the intelligence
Is it-
officer,
Is it
intelligence officer,
maintainable? Second appeal
In
before
fact,
court.
two revision petitions have been filed.
second appeal authority. The particular officer having delegated with power of
There must be,
intelligence
there must be. a
cannot
act-
assess
There must be an act, the section which says how the power can be delegated. If the section provides that how this is the mode of delegation. So
Notification is not there. What happened? Two STA.
let us see,
Sir, whether it is gazetted or not, if you produce the gazette, then
sir, show us the law. Yeah, sir. When the legislatures are enacted,
Your Lordship,
if the power of delegation is provided in the statute, it also must contain the modalities of conferment of or delegation of power.
those are
If the section says that the power should be delegated and it should be notified, and the section defines that what is the meaning of the word notification, that it must be published in the official gazette, then it has to be done in that way. Every act contains so.
Your Lordship.
Show us the act straight away if it requires the notification to be gazetted. If it is not, then
No, what my-
perhaps this question is decided in SJC number 98 of 1994.
Exactly.
Please produce that order. This court ought to have disposed of that matter.
1998 and 1991. Those are related to this case, particularly this case. Your Lordship, I have.
SJC.
sir, I'm requesting you to place a statute. Can you place a statute?
Your Lordship,
I have a lot of, I would say, the shortcomings because I always believe in the statute, then the judgments. Let us first see the statute, what it says.
those are there, Your Lord. What my.
Show us this act.
This case is may not be, Your Lordship, this case may not be appropriate to show all these things. Why I'm saying, Your Lordship.
You want me to be ignorant all the time.
No,
What are you talking?
Your Lordship.
I wanted to enhance my knowledge. You do not want me to go through it. What is this?
What he wants,
Show me the statute.
what he wants to impress is that
That it is nothing. There is-
4,900
the Official Census Act
4,933 is the
itself is
tax
repealed by
equivalent.
VAT, but VAT
4,933 is the tax
So far as
equivalent.
appeal is-
4,000 rupees.
4,933 is the
At that
tax
time, it was
number.
valuable.
Prior to filing of this writ petition on the same subject matter, Your Lordship, on the same case, two SJC have been filed, tax revision, against the tribunal order. As per my inquiry, those SJC have been disposed of in 97/2001. So pursuant to that disposal, these writ petition may be infructuous, Your Lordship. Your Lordship, for that reason, let the question be open, Your Lordship, maybe
which I do not want. When there is a repeal and saving clause, then one has to understand that if the proceeding is already initiated before the VAT came into force, whether those proceedings are saved by a repeal and saving clause or not. If it is saved, then in that event, we have to decide this on the basis of a repealed act.
What I pray, Your Lordship, if it be urgent,
Whatever, you show me there is a Odisha
Sales tax act.
Sales Tax Tribunal Act is there or not?
Not tribunal. It's a sales tax.
Sales Tax Act is there, then show me.
Your Lordship, also the notifications have been quoted in the writ petition.
Sir, notification by an officer. Simple notification.
All the notifications have been gazetted, Your Lordship.
Gazetted.
Gazetted.
That is what I wanted.
Your Lordship, gazetted notifications are there at paragraph. Your Lordship.
Not there, sir. The last two, which the tribunal has quoted, the territorial jurisdiction which is conferred by the commissioner, that is not there. That is not reflected. SRO is there. Three notifications are there. Rest two notifications, three notification and four notification. Those gadget notifications are required.
From time
Which
to be
I-
allowed, I don't have the file brief and I don't have.
So, so I have seen the.
Your Lordship, I got on, I cannot. Your Lordship is competent in OST.
Who has delegated the power?
Your Lordship, Commissioner has delegated the power
Delegate.
and Commissioner has the authority to delegate
Yes.
the power.
However, the Commissioner Section 3A does not provide for. No difficulty. State government can appoint. No, that is a.
No.
Page five,
Page-
in fact, these notifications could not be produced before the tribunal. It is considered here that these, Your Lordship,
You come
that
to,
the
you come to, sir, you come to page 6.
Your Lordship, page 6, Your Lordship. Your Lordship,
Page 6 is one notification.
Your Lordship,
Where
That
is the- where is the-
intelligence circle,
interstate.
intelligence circle,
Your Lordship,
entire state of Odisha. Right,
Your Lordship,
you have given a number. This is finance department number 18109 CTF 5262F. Whether this notification has been gazetted or not. SRO, where is that SRO? Unless it is SRO, it is not gazetted.
well,
It is only a file copy.
Your Lordship,
You have reflected file copy only.
well,
So tribunal says this notification, unless it is gazetted, it can't be treated to be notification to be given effect to.
well.
So here also you have not reflected. When you challenged that you could not produce before the tribunal,
Well,
in your writ petition also you have not stated that it is printed or published.
This is what has to be done because Section 3, subsection 3
well,
of the Act
Sure.
that gives the power of the state government to appoint any person other than
well,
the prescribed designation. Correct.
Your Lordship,
To discharge the functions of the commissioner.
well,
And the commissioner was also authorized to define the local limits.
well,
If you come to the rules, Rule 3
well,
of the Odisha Cell Tax Rules,
Your Lordship,
it says that 1A was introduced subsequently.
Your
It
Lordship,
says that the Commissioner of Sales Tax may from time to time, by notification, specify the local limits of the jurisdiction of the inspector appointed under the Act.
well,
Correct? Then, 4, if you come,
Your Lordship,
the state government may by notification in the Gazette
well,
constitute area in the circles over which the assistant commissioner or the cell tax officer or assistant cell tax officer as the commissioner
Well,
may specify by notification shall exercise jurisdiction. This is what is done.
well,
Then 5 also says by notification in the gazette.
well,
So what is required is that it should be gazetted. The tribunal has held that it is not gazetted.
Your Lordship.
If it is not gazetted, then in that event, the power cannot be exercised by him.
Your Lordship, prior to 1980, what I found, prior to 1980, Your Lordship.
Sir, these are the amendments which are brought in 1970s
Your Lordship.
and 60s. 1A was brought in 1959, sir.
I praise.
So 1980, what are you talking? Then this act was, this section was, rule was there.
Your Lordship, I pray some time may be granted.
What
Because in the
sometime?
meantime also some
This
judgments.
is
have
the
been
open
passed.
and shut case,
Some judgments. have
30
been
years.
rendered.
What judgment? Brother, there is nothing. If that is the only point.
You should go to Commissioner's Library.
Well,
There all gadgets are paginated. According to pagination, it would be available under Part 3 or Part 3A Gazette. They are all bound in bound volume
well,
up to 1985. It is there in the Commissioner's library. You have to search for them.
but in fact, now the brief.
You have never gone to them,
Your
that
Lordship, I am
place. That's
I'm
why you
just,
do not know.
blind. Your
Many
Lordship.
occasions I had the occasion to go.
Your Lordship,
So
I have learned all these things from you, Your Lordship. Your Lordship, some time may be granted. Also, the brief is not available.
Oh, he has quoted the 3-4, which I just read.
Your Lordship.
In a judgment, he quoted rule
Your
3-4.
Lordship, for in this seat petition, Your Lordship, I think that the department has submitted that prior to that notification, some notifications were there and those could not be.
No,
submitted.
please consider. It says, as I say, that the revenue further contended that the order passed by the commissioner may be taken as sufficient compliance of rule 3-4.
Your Lordship,
As of the said rule does not say that such notification of the commissioners is to be published in any gazette. But the learned counsel on the other hand, that notification means the notification in the gazette and as order passed by the such and such has been published without that. And then it says that though the notification has not been defined either in the act or the rule, meaning assigned to the same from a general clauses act is to be accepted. The said contention of the such and such has force, and it is an admitted position that it is not gazetted because your contention was that rule does not prescribe for gazetting of the notification.
Your Lordship,
So you have to proceed on the basis that is not gazetted.
Your Lordship,
You can't take a different
verify
route.
verify the status, Your Lordship, because against those.
Status means
Your Lordship.
your argument, I said. Your argument, what I read.
Your Lordship,
I am saying, I am again saying, the revenue, you are representing the revenue.
Well,
The revenue further contended that the order passed by the Commissioner of Commercial Tax may be taken as a sufficient compliance of Rule 3-4 of the said rule, which does not say that such notification of the Commissioner is to be published in any gazette. Your contention was it does not require any gazette publication. That means the notification was not published in the gazette.
let me-
Otherwise, you could not have argued
Let it
this.
be adjourned to some other day.
Order.
Let me verify the status of those SJC, those two SJC.
And notification means it has to be gazette. You can't do it by virtue of this.
Yeah, let's say by
Whether you want to press this application or not, that is.
Yeah, let's say exactly that because this matter will be infructuous because if those SJC have been
Sir,
disposed
it's a
of.
30 years old matter. Unnecessarily, it is pending here in this court.
Well, let's say only on my verification, this will not be placed, Your Lordship, on the next day.
Come day after tomorrow, Saturday.
Some more time.
What more time? Nothing.
I have no brief, I have to take Your Lordship's brief.
Do you have a brief? Yes. Give it to him for his study.
Yeah,
Give it to him.
get a pen drive. Take.
Oh, it is also there.
Scan
So you scan copies is there. Take.
Item number 2.
This tax revision. Your Lordship, for a moment, page 24 may kindly be looked at. This is also the file is not traceable in my opinion.
No, sir.
But I have verified here. The petitioner has considered page 24.
Has the defect been removed? Oh, it is removed. Yes.
Party is not appearing. Party's counsel is not there.
Who is appearing? Who is appearing?
No, he's for the.
No. For the petitioner.
Petitioners are. Maybe Vasudev Panda. Mr. Vasudev Panda, perhaps.
Brother, what?
Item 3.
Item 3, sir. Yes, sir. 63.
8-way, CST 8-way.
63.
Page 6 question of law is the finding of the tribunal is 37-38. Declares that 8-2A or 8-2B.
Ma'am.
So,
Can you identify, because do you know these,
Are they there?
also,
There. Yes, Philip Kumar Lenka, then Sukratu Mehra, Dilip Kumar Nayak. Find out actually Lenka, whether Lenka is there. I find that he has signed the original number, others have not signed.
Yes, ma'am. Signatures there.
Oh, yes. What have I, this hand copy does not show, only two signatures.
So A4 size scanning was done. This is.
At that time, legal says local of was filed.
How do I?
That experience I had. In the department I had that.
But it should go to the next page. There's
So the scan call are reduce corner A4 tab.
Who is it?
Huh? That option is there.
Who is it?
Yes, ma'am. I've instructed him.
Yes.
We have an option there. The speed
Yes,
scan.
Can be
Find out.
It took place.
Yeah, we are keeping it to you.
Ma'am. Item 4.
I mean, VC, my lord. My lord, it may be infractions by now. After 20 years, it is listed. It might be infractions, my lord.
No, rephrase your submission.
My lord, that cannot be submission because I want my presence only, nothing else.
It is infructuous, we can go. Maybe
Yes, fine.
infructuous, there is a doubt.
My lord, after 20 years, I have no instruction also. I am unable to trace my file also.
But beverages corporation is still functional.
Nothing may pass any order. Limitation is also there.
Nothing has happened because there is no order which is passed since 2005.
I think never moved.
Never met. Very good.
Mr. Das,
Hmm.
it has never been moved and there is limitation.
Yes, madam.
So can we are proceeding to dispose of the limitation application. So
Yes,
then
yes,
any
yes,
problem?
madam. Yes, that will be better.
The instant review application is All other pending
Item for
miscellaneous
that
applications.
day, Your Lordship. Item 1 on Monday. Your Lordship has urgent to Saturday, day after tomorrow, on Monday. Item 1.
Item 5, sir.
Some number 6.
As an application, I'll file an objection to that, Your Lord. He is not a necessary party.
I am
Lordship may
necessary.
hear me on my interim application.
What?
He has filed an application for intervention, my lord.
Intervention in a pending matter.
Yes. I
Where is
file an
that
objection to
application?
that, my lord.
Where is that?
There will be a fresh writ petition. The first writ petition is a fresh writ petition, and the pending matter, the pending writ petition is the connected matter, arising out of the same
Where
dispute.
you have, for the
That-
intervention, you have filed an intervention.
In the
For
first,
the second
writ
writ petition, I am the petitioner. The first writ petition was filed during pendency of the second writ petition, when the matter was substantially heard and it was reserved for judgment. Thereafter, it was released from the part heard. At this juncture, this writ petition was filed.
So
And
your,
Without,
what is
without
your
including me as a party.
sir, what is your writ petition?
But my writ petition is
What
challenging.
is your grievance? I mean, just give me a nutshell. You did not
Yes,
let
yes,
me open the
I'm
bill.
giving a not.
Let me understand for some other reason. Let
There
us-
is a advertisement for surgery. And
For long-term leave.
long-term lease for
Correct.
5 years. I am also an applicant. My one friend Kaland is also correct. Both have filed on the basis of an advertisement issued in 2019.
No, that is the same advertisement. Both of you are agreed.
Same.
Now, I'm just asking, what is your grievance?
My grievance is that he was selected and his selection was again negative and I was selected in his place. Thereafter, he preferred an appeal.
Challenging his cancellation.
His cancellation.
So that matter is pending.
That matter is pending.
that
challenging
my
is-
appeal was allowed.
Appeal was allowed.
Appeal
His
was
appeal was
allowed.
allowed.
Appeal before the appellate authority.
Appellate authority.
Correct.
Appeal was allowed.
Correct.
Thereafter, my lord, he came before this honorable court saying that
Challenging the appellate order.
yes,
Appellate challenging the appeal.
telling that I was not being heard. I am a necessary party because my
You were not implemented as a party.
in the
I was not implicated.
in the appeal. Listen, please. In the appeal, I have not implemented him as a party. Then, being agreed by that order, he came before this honorable court. This honorable
So
court
let me, yes.
disposed of the writ application, the two writ applications that saying that he should
Setting
be heard.
aside the order of the appellate authority, impleading him there in the appeal
Best.
and the appeal to be heard in his presence.
Yes, madam.
Yes,
Appeal
then-
was heard and appeal was allowed in my favor.
Correct. Again allowed.
And again allowed in my favor.
Correct.
He challenged that
He
order.
challenged that order of the appellate authority.
Yes, madam.
Correct. That
Yes.
is,
Yes.
yeah,
What has happened now, madam?
now,
During pendency of the that writ application, this honorable court never passed any stay order.
correct.
I was, my lease was executed in my favor.
It was
Agreement-
executed.
Yes, executed in my favor. I was operating the lease.
Correct.
All of a sudden, my letter was issued from the office of the Advocate General to directing the Tahsildar to stop the query operation in pendency of the writ application. So there was no stay order passed. I challenged that because I had not challenged that order because that order, that writ application was heard substantially and was to be the judgment was. But since the judgment was not delivered, it was released again. It was been put to her. I challenged that order of the
Authority
authority
stopping the query.
that is my second
query
writ application. Yes, ma'am. That is the second writ application. And since my lease is also still valid till 2027.
But once he has made an objection, raised an objection, then on that objection, if your query or activities is stopped, then in that event, will you not made him a party in your writ
No, he did not make any objection.
Then who raised an objection?
That you will also may kindly see that the letter of this Advocate General Office was issued a letter. In spite of that, there was no stay order granted in the earlier writ application. A stay order.
Sir, when there is a reference of a writ petition
Yes,
which is pending
yes,
and the office of the Advocate General has issued the letter
yes,
showing that because of the pendency of this writ petition, query activities must be or mining activities must be stopped.
yes.
Then you are aware that this writ petition is filed by somebody, number is given.
Yes, I was a party. I had participated.
You
in it.
were a
I am
party.
party there.
Then in that event, if you have subsequently, either there were two courses open,
Yes,
as I know, understood.
madam.
You could have come in that writ petition, file an IA saying that this cannot be done.
Yes, madam. I filed that.
Or you could have filed an independent writ petition.
Madam.
In the independent writ petition, you'll have to make them a party also.
Well, if I filed that.
Because of his writ petition, your mining
I-
activities was stopped.
Madam, he is no, madam, I am not agreed by any action of his, madam. It is because that his application is tagged to it, madam. I'll make him a party that I have no objection to that, madam. But this thing,
I'm just thinking in the light of intervention application,
Ma'am.
sir. I have not gone into the merit.
madam,
I'm
and
just
what
thinking in the light.
what falls for me,
Let
Lord,
us-
my lord,
Yeah.
now, that I had in fact filed an IA before that in that writ application, making this matter to the knowledge of this honorable court. This honorable court knows, so you cannot get a relief in his writ application. You better file a fresh writ application.
Then will you not made a party, made him a party? Sir, I am not entering into the merit. Please have that clarity in your mind. We are not entering into the merit. We are simply restricting our consideration to intervention application.
Madam,
Whether he is a necessary or a proper party, we have to ascertain that.
that your lordship, it is up to your lordship, my lord.
Not up to, unless we know the subject matter.
My lord,
How can
I
I,
am
this is the subject matter which you told.
only second.
So in that event, he is a necessary party, at least a proper party, not a necessary but a proper party.
I'll make him a party. I'll make him a party.
Allow his application.
My interim application, that is my problem, is my lord.
No, I understand. We'll fix the matter. Don't worry, but let us see. Where is the interim application?
My lord, that is IA number.
Like this.
Flag D, my lord.
The
Agreed.
Sought for instructions, Your Lordship.
Why, what for?
Next week, Your Lordship, we follow the 18th them.
Oh, cancelling the tender.
Yes, Your Lordship.
Out of the same tender notice, there are two other matters which are pending.
Anyhow, only thing is, they have not awarded any contract to her,
No,
anybody,
not.
cancel. He has come after 2 weeks.
The other two matters are listed on 28th October. This can go.
28th October, and along with this next.
Item number 8.
My lord. My lord, seeking Lord's permission to appear online, my lord.
Rate
Short
in
issue.
the rate, tell me maintainable.
My lord, short issue, my lord.
Yes, I understood. The relief I have read, tell me whether it is maintainable.
My lord, I am, my lord, supported by two judgments to invite my
Sure.
lord's indulgence. My
Go
lord,
on.
before that, my lord, my one-line submission. Before that, only one-line submission.
Yes.
But this ADR, my lord, mechanism, my lord, is right to access to justice. My right of access to justice.
I think the A has to be understood. The
I know.
full form of A.
My lord,
When you talk about ADR, then
The-
what A stands for?
my lord, the conciliation is the A. Mediation is, my
No
lord,
conciliation, sir.
my lord, then, my lord, will you just try?
When A stands for alternative,
Yes,
then
Lord.
what does it mean?
Lord, the alternative beyond, my lord, the normal judicial activities.
Absolutely. Now, when you understood, then please tell me that the mandamus of such nature can be granted. Show us that judgment.
But my lord, my submission is that Lord can straight away mediate. The power is so vested by virtue of Supreme Court direction in so many.
I am quite conscious of the.
I go down, my lord.
I
Then, my
think
lord,
AFCON judgment of Justice Ravindran. I
Lord,
believe
I will.
AFCON or AFCON. I always need a confusion.
Afcon.
Yes, AFCONs, my lord.
Yes, AFCON.
Lord, then
No, there is AFCON judgment also
yes, Lord. Lord, I will bring.
on a jurisdiction.
Lord, I will bring Lordship till 2021 as to what is the constant view of the Supreme Court. Before that, my lord, my submission is that
No doubt about it. Mediation is always a court annex mediation or a litigation annex mediations are permissible. There is no difficulty,
This
sir.
is-
But
this is-
raise
this is more-
jurisdiction for
I'll
this
come to that.
relief.
I will come. I'll come back. My lord, in fact, this is more than, my lord, the permission. This is something, my right of access to justice, because I have no other methodology. Because my lord, I cannot straight away go to suit. The mechanism which has been described and the parties have agreed to. My lord, my submission is that, my lord, that should be honored. Then, my lord, I will draw.
Sir, section 11(6) of the arbitration and conciliation has undergone a sea change because of this. When there is already a mechanism provided before a party can invoke that arbitration clause,
I go down.
if the party fails or neglects or denies, then you can definitely come.
Lord, I'm not only on 11.6, Lord. I'm drawing Lord's attention on section 89 of CPC.
No, definitely. I am conscious of that also.
I also draw Lord's
but-
attention on
but-
442 of
again-
Companies Act.
But
Lord,
in a rate of such
Lord,
nature,
then I will draw Lord's attention straight away.
please, though judgment show us.
Lord, the first is, my lord, Unitech. A, my lord, I have marked it A
Give-
because on last date
give
of
me-
hearing I was
give me
facing
that.
some. Lord, the flag A.
Unnecessarily valuable. Let us see on that point. If the judgment says yes, no difficulty.
And para 33, my lord, without wasting Lord's time. There are arbitration clause and, my lord,
Yes,
adjudication.
judge.
Oh,
One.
sorry. Oh, sorry. My apologies.
So does it help you?
Lord, why I say so, my lord, I
Because
am
in a court, I am conscious of the ABL International. That's the first landmark judgment, and there are something attached to me also when I was at the bar in your position. There is no difficulty. So I know the entire episode of ABL International. It originates from a Calcutta, and how it was drafted and how it has been moved, I am all aware of it.
my lord, I am more privileged than my lord that
So because the very company was all along my clients when I was at the bar.
my lord.
So I am aware of ABL International.
Therefore, I know more privileged.
That is the different case. That was a different case where something more happened. And in that perspective, Justice, if I am not wrong, Justice S.B. Sinha's judgment is there as ABL International.
Yes, I think Justice Hegde, my lord.
Hegde or with Justice Sinha or what?
Lord Justice B.P. Singh with Justice Hegde, my lord.
Hegde. So anyhow, so that was the position there. It says that writ jurisdiction in a contractual matter is not absolutely taken away. There is no difficulty the court may. It has to be judged on the touchstone of Article 14 of the Constitution.
My lord.
What Article 14 says? Is it a case of any violation of Article 14?
Arbitrariness, my lord, straight away.
No, sir. Equality
Unreasonableness, my lord, straight away.
equality before the law. I think the contractual matter one has to understood in
But
that.
in fact, if the state has, my lord, then next one also, my lord. I think, my lord,
Will be another judgment.
but I will draw Lord's attention on one para of this judgment and then we'll move on the other. Because why I say, my lord, then the methodology was drafted by the state. The state says that, sorry, I'm not following it. Is it not unreasonableness, my lord? Is it not arbitrariness, my lord? I should be straight away being thrown out to go to the court, file a suit.
Sir, there is already a clause. If he does not, then that is why this was.
Therefore, I say that why not that clause?
These were all in the Arbitration Act.
There is no arbitration in my case.
No, that's why I'm saying these are the principles which emanate from there.
I go down. But in fact, why not the maintenance must be directed to enforce the clause, Lord? Because the clause is giving me a right. Can it be said that ADR mechanism is not a right? It's not a right of justice. Then it should be waived, Lord. The question is that if it is not enforceable, then what is the purpose? I don't want Lord to enforce it, and I don't want my Lord to adjudicate it. I only want to let there be a direction to them. That if there is a contractual provision, and contractual provision is drafted with the full intention, then why to just make it an useless formality? Man, only thing is that, Lord.
That means in other way, what you cannot achieve, you could have gone for a specific performance of that part of the contract before the court. You can seek for a specific performance decree. Can a writ court grant? You are trying to enforce any terms and condition of a contract. Does it not require a specific performance of the contract?
Lord, I don't want. I want only a direction. Let them say no.
Can a writ court pass a decree for a specific performance?
No, I don't want. I want them to pass a decree. I only want that.
What you are doing is that in an indirect manner you wanted to achieve something.
Lord, with humility, my Lord, I am not. I don't want Lord to pass a decree. I want only my Lord to direct.
Then what does it mean? Suppose you are seeking that they should strictly adhere to clause 24.1 of the contract. Pass a mandamus.
They can
24.1. Is it not in other way granting a decree for specific performance of a contract?
Lord, then, Lord, there is no cantankerous issues, my Lord. But simply
then what for amicable solution? If there is no contentious issue, then what for the amicable solution?
Cantankerous issues for your lordship's court. My Lord can only, my Lord, lay the hands off.
No,
when my Lord, then just see 24.1.1 and 2-3 more judgments, my Lord, because this is something.
Another judgment. You have cited ABL.
Lord, ABL, Lord would give me permission just to read one para for my satisfaction. My lord would see page 31 at the bottom. It is, my lord, the page number is marked.
Yes.
Article 12, it starts with Article 23.1.
I have read therefore.
However, my lord, I know, my lord, that my lord, in fact the principle, the parent judgment was dealt with by lordship, my lord. So I'm a little more privileged that at least I can, my lord, there would be no efforts, my lord, in convincing your lordship. I will certainly draw lord's indulgence, my lord.
Yes.
However, my lord, the presence of an arbitration clause within a contract between a state instrumentality and a private party has not acted as an absolute bar to availing remedies under Article 226 if the state instrumentally violates its constitutional mandate under 14 to act fairly and reasonably. Relief under plenary powers of Article 226 Constitution could lie. I am not, my lord, that please direct them to give me the relief. I only want that there is a clause written with some intent and purpose. The state is violating that clause. Kindly direct them, yes, to just to constitute a conciliator and decide it. It may be, my lord, incorrect. The conciliator may go against me. But question is that, my lord, something has been written, not acting upon is nothing but arbitrariness and unreasonableness. Then Lord, two more judgments. One would be, my lord, by in Uttar Pradesh powered transmission, my lord.
Correct.
Flag B.
B, my lord, flag B. And my lord, 65. Because in all these matters, my lord, the court has adjudicated. I am not on the adjudication part.
Yes.
My lord, the 65 is the arbitration clause. So I'm ignoring that, my lord, because I'm not wanting any adjudication from your lordship, my lord. Then 66. Even though there is an arbitration clause, the petitioner has not opposed the writ petition on the ground of existence of an arbitration clause. There is no whisper of any arbitration agreement in the counter affidavit filed by the so-and-so to the writ petition in any...
Page.
My lord, 40 at the bottom, my lord, typed page 40. But my lord, 40 is there was an alternate mechanism, my lord. Arbitration was the alternate mechanism through which the discourse could have been resolved. But I am drawing lord's attention on 66, para 66, page 41.
Yes.
My lord, 66. My lord, I'm just reading two lines, my lord.
Raman, from which judgment you are? Uttar Pradesh judgment you are referring?
My lord, yes, my lord. Uttar Pradesh.
Please, which page? Page 61? Running page or what?
My lord, page 41, running page.
41 because the Uttar Pradesh judgment starts from page 50.
My lord, page at the bottom, my lord.
Yes, to page 49 is the Unitech judgment which you have.
My lord, I think, my lord, again I am in problem, my lord. I think my page and my friends.
Can you show me the Uttar Pradesh, the judgment paragraph?
My lord, 66.
66.
My lord, page 90, my lord.
90.
Running page 90.
Mine is not running page. I'm sorry, my lord, I'm putting lordship in difficulty.
Yes, sir.
65, just for a glance, had arbitration clause.
Yes, I have seen that.
66, my lord. Even though there is an arbitration clause, petitioner herein has not opposed the writ on the ground of existence of an arbitration clause. There is no whisper of any arbitration agreement in the counter affidavit to the writ petition in the High Court.
The existence, sir, it can be waived under the Arbitration and Conciliation Act.
Last two lines, just last two lines.
Yes.
In any case, the existence of an arbitration clause does not debar the
I am
court.
conscious of the furest judgment of the Supreme Court as well.
Yes.
It says not an absolute bar. There is no difficulty.
Then, my lord, one more, my lord, that Surya construction, even for the money part where there was no, and in all these matters, my lord, the relief was directed. I am not on the relief part, my lord. Then Surya construction, my lord.
The court basically was not itself to decide the because you know that to direct another.
Lord, one by my lord, one in Surya construction. These are all of 19, 20, 21, Lord. And then next, then Justice Sadasivam in zonal manager. Then I
Surya construction is in flag D.
Yes.
Flag D, my lord. And I will be drawing Lord's attention on the page over, my lord. The first page, only 2.5 page judgment, Lord. Next page, it is clear therefrom. From the aforesaid order dated so and so that there is no dispute as to the amount that has to be paid to the appellant. Despite this, when the appellant knocked at the doors of High Court in a writ, the impugned judgment dated so to dispute the writ petition, stating that disputed question of facts arise and that the amount due arises
No,
out
no,
of
no, I
the.
understand. There was no dispute as to the admitted amount, no difficulty.
Here, my lords, I have already directing them to the relief. I am not seeking any relief, my lord.
I understood. Then
My
next
submission
judgment-
is, my lord, my
Next
sorry,
judgment,
my lord,
Central Bank, Davis Park.
yes, my lord.
Yes, which paragraph?
My lord, para 15. That is, my lord's. I think my lord's time, my lord, of 2010.
Yes. Para?
1 5 minutes.
There are many paragraphs. I do not know. Is it
My lord,
quotation?
my lord,
No, no.
if you
Can you give me the page number? What
yes,
is
sir.
it?
My lord, 102.
102. Yes. Para 15. The learned counsel then contending. This is the paragraph.
My lord, I think this one is not the correct paragraph. Learned counsel. It is clear that. Not counsel. Page number 15.
Yes.
Last page, last page, 15 minutes.
Yes, yes, I have.
Clear that the
I have read 16. I have read
15, 16.
as well.
15, 16, just two last
Yes,
paragraphs.
quoted paragraphs I have also read.
Then my lord, straight away the last page of the judgment.
Paragraph 15 also.
But that was the, my lord, the last one, my lord submission. The contract, if there is a clause for arbitration, normally it should
That
not.
I have already, that is there. There is no
My-
doubt. If there is an arbitration clause, that does not mean that the jurisdiction cannot be entertained.
Lord, my submission is probably this would not resolve the entire issue if the conciliator is, if a direction is given. Or let the notice go, my lord. I would try them to at least convince them to have a conciliation so that my lord would see the rigorous procedure in 24.2. If no conciliator appointed, then I will have to file a suit. Then it is nothing but the wastage of time, wastage of money, wastage of the court's time. So I say, my lord, when the mechanism is given, what is wrong in my lord?
Yes.
Probably, my lord, my humble submission that probably my notice, only notice would solve the problem. On the merits, my lord can my lord exercise the jurisdiction, can say that sorry, it is not something there. But my lord, this would resolve everything. And then I have no other my lord, methodology prescribed in the contract. No other my lord. Had there been arbitration or something, or second mechanism that if you are not satisfied, straight away suit. If there is no conciliation, then straight away suit. And the conciliation, my lord, starts with the word shall, my lord. If I can say that, my lord, it should be read as shall only, because
Sir,
the
if you go for a suit, if the court finds that there is an element of any kind of amicable solution through mediation.
then in
Section
that,
89, you are aware. Section 89.
but in that eventuality, my lord, we are foregoing 24.1.1 as redundant.
That's true.
That
That is what I'm
this
saying.
clause should not be given effect to.
Because then I tell you the answer lies which the judgment you are referring at page 105, just above paragraph 15 which you are referring.
My lord, in the recent decision of Karnataka State.
Yes, please read that. What is that paragraph 38 of that judgment?
Although ordinary a superior court in exercise was writ would not enforce the terms of a contract qua contract, it is tried that when an
It is
action
really
of
enforcement of a contract qua contract.
Lord, may I, my lord, submit? Then, my lord, what is the power of, my lord, the dispute under 14?
Sir, there is no, you can't say that you are remediless. Please consider.
Lord,
We are at a stage whether there can be an invocation of Article 226 pass in these facts and circumstances?
My lord, then I am really remediless so far ADR
No,
mechanism.
you are not.
Then
You
there
are
is no
not. We will
purpose of
say.
ADR. Then, my lord,
No.
there is no purpose of ADR.
No.
The writing of 24.1
What
is
is
now
that? Would be just EB remedium. This is always, I am conscious of the legal maxim.
in fact, my lord, even if they do not write anything, my lord, this filing a suit is my legal remedy. I don't
Your
require, my lord,
right is still there. Your
before I
right.
say that, my lord, there is no need of contractual enforcement. For filing a suit and filing of
Yes.
writ and coming before your
Yes.
lordship, there is no, my lord, contractual enforcement.
Yes.
Contractual enforcement is when there is a provision in the contract not complied with.
Then we'll suppress A.
The filing of suit, when the filing of suit is otherwise right, there is no provision of writing in the contract that if I am agreed, I will file a suit. I think there is no need of writing. The law is law. Only enforcement would require, my lord, of a provision, my lord, which is contractual requirement, something more than law or something less than law, which is giving me a right.
Yes. Anything more, sir?
But, but what should I say, my lord? I will only say that, my lord, even the notice probably would, my lord, absorb this dispute because we are sharing a long relation, my lord. My contract is till 27-28.
Yes.
For me, my lord, even for this aspect, my lord, accumulate all the disputes and then go to in a suit or in the High Court, my lord. So that would be very difficult, my lord. Therefore, my lord, something was given not as an useless formality, but something with, my lord,
Yes.
some intent.
Yes.
I think my lord is not inclined to.
No, why you feel? We are still, my mind is open. I put certain queries to you. That's why, only to just make you that you can, you can dispel whatever is playing in our mind. It's a more transparent and I would say, the fair manner of understanding the proposition of law. We are not on a facts, on a proposition of law.
I go down, my lord. Yes.
That's the only thing.
My lord. Facts, my lord, certainly, my lord.
No, we are not. It is undisputed because the agreement is not disputed. The clauses therein is not disputed. No difficulty. We are on a pure question of law.
Then I will rest, my lord, leave my case in Lord's hand, my lord.
Yes. Which for the state?
Mining corporation. Mining corporation.
Yes. Are you not representing them?
The panel of counsel.
Who represents them?
Mr. Prabhakar Muduli is there. And so also I am as a counsel for them. But I am only handling the service matters for the mining. These are mining matters. So
Who handles the mining matter?
Prabhakar
Prabhat Kumar Muduli.
Mr.
Where is he? Can you bring him? Yes, we are just keeping a matter where you just bring him. We will decide these points. Yes. Yes. Hey, just keep it. Just give it to me. Let's call the next.
Item 9.
Yes, sir. Yes, notice, give, respond. Who is for the DSG has to respond. Union of India, sir? What do you say? You want to take instruction?
First time.
Yes, that is what we are asking you. Are you taking
Yes, sir. I'll take instruction.
instructions? 2 weeks.
For 1, 2, 3.
Item number
Yes,
10.
I'll take instruction, my lord.
Yes, we are giving you 2 weeks time to take instructions, sir.
My lord.
Item number 10.
Regarding the charge of royalty for the limestone transportation, like whether it will be at 80 rupees or 90 rupees.
I'll just take your lordships on the last occasion and show your lordship that page 30, your lordship might come back to that page. And then 31, where the conditions have been imposed. And then I'll come to about 10.7, which they said they rely upon. Lordships on the last occasion, asked them to take instruction on that ground and the other expectation. Finalized comments have been sent for approval. The department. These comments have been prepared by the mines officer, sent to the director of mines for approval. So that approval we are not restricted. We are granting you 2 weeks time to respond by a counter affidavit. We'll consider 2 weeks time.
Man.
Subject to my environment staff, what this was one more case where the issues, certain issues have been framed on the same same issue, but there the difference was they were given a so cause. And against that, they had gone to the mines tribunal, and that order is under challenge where the issues have been framed, same issue.
Let me decide one case,
Yes.
it will follow the others. Don't worry.
No,
This will be a lead case.
No, there, my lord, the issue also, in addition to this, they have said that.
Why should I? Unnecessarily you complicate this matter. So let us decide this matter and thereafter we'll consider what that matter is.
Because during the arguments, we might be relying upon that.
Let me, no difficulty. What? These
Item
are the interlocutory observations.
No, the issues have been framed while issuing notice.
Correct. That's why that's an interlocutory order, sir. It has not reached finality. So no difficulty. Those are not binding at this
No,
stage.
no. Those issues, my lord, we would be, my lord, addressing your lordships.
Okay. Yes.
Item 11.
2 weeks rejoinder, 1 week, 3 weeks, give a date.
Yes, ma'am.
Yes. Connected matter, since there is already a counter they had filed, I don't know if they might adopt it or there might be a difference.
We have got a paravise comment, so naturally they want to give an independent.
Small rejoinder. my lord.
Yes, let it. Small, I have given 1 week. Yeah, leave you.
Item 11.
Where is the virus is under challenge? This matter? 11?
Item 11. my lord. 2320 the previous.
11 ही तो. हाँ.
The last occasion, your lordship was directed to take inspection by.
Oh,
Here the allegation with PIL is that you got once of rupees 4 lakhs had been allotted in the year 2023 for renovation of a Ganesh temple.
how can you,
It has been diverted.
Diverted.
The instructions, Miller. In fact, that fund, Miller, has been utilized and the temple has been renovated. Temple has been renovated.
Let them file a counter, my lord.
not counter in a PIL?
My-
What is the concept of counter in the PIL?
Documents, my lord, who's.
Whatever, you put it on evidence.
Yes.
Stop. It is submitted by the. Virus is challenge, sir. Yes, now the Advocate General is to be given a notice.
Virus of statutory
Then he is entitled to a notice. Give a notice.
Giving.
Just can you give me a nutshell? What is just give a not argument, broad
I'll tell you without
broad issue,
issue.
so that there will be a food for thought for us also
Right.
in the evening.
But powers and functions of an executive officer of a Panchayat Samiti
who is subordinate to the chair.
Is subordinate?
Subordinate to the chair. That is settled position. That's a law also. And the BDO or the executive officer.
Can you again repeat?
Three-tier panchayat samiti system. Three-tier panchayat.
No, you say power of the
Executive officer of a panchayat samiti law.
who is an appointed,
Who is and subordinate to the chairman.
who is a elected or a nominated or appointed.
Appointed.
That is what I really wanted. The issue is appointed.
He just.
Whether he is subordinate to.
He is, as per law, subordinate to the chairman.
Correct.
So his duties and functions are clearly defined in the statute, what
Correct.
he is to do, and under the command of the Samiti and chairman as well.
Correct.
Now there is a particular rules in the accounting procedure rules which empowers the executive, which that executive officer, that he will disburse money to the different persons without any approval from the Samiti or chairman as the case.
Okay. So that financial autonomy is given.
And that runs contrary to the
mandate of that unless because under the Panchayati Raj,
right.
The elected body who has to decide as a collectively that what is to be done, including the financial. When should we fix? Advocate General is.
They have challenged the rule without challenging the provisions under the Act.
No, cannot, because if the Mr. Then you are opening again. You are entering into such a dangerous domain, and then inviting me to speak more.
Act is in order.
The flip side of the compliment to my learned friend's argument would be this, that the BDO ends up enjoying power without accountability. Now, accountability is the elected representative, but the power, financial power is enjoyed by the BDO to do as it chooses. That is the.
You can put it in a different way.
Balance. That is where the issue is. And now they are enhancing the financial limits.
No, that is clause B of this prayer.
Right, exactly what is on point. And now they are enhancing that limit.
More devastating, Lordship.
And even more devastating is this, my lord, that supposing the chairman for some reason, he delays the approval of the bill by 7 days, the collector can take over and immediately direct for. So therefore, virtually it becomes a titular kind of a position where all the financial independence is robbed and susceptible to.
Interesting point.
That is the point. So whether that was envisaged under 243
When Advocate General will be, or you will argue him.
Harish has been challenged.
Say the virus of Rule 16 within bracket 1 within bracket 2 of the
I may be pardoned to mention, my lord.
Whether the tender committee has the power to relax any of the conditions in my lord. The first manner that the units, then manner name of the tenderers. Manner come to serial number 4.
4,
Yes.
143.
CMC unit 1.
Suvendu Sahu.
Yes, Subindu Sahu.
He is the opposite party number
5.
5. And you are?
Yes, madam.
You are?
And for the manner I am.
Are you Tarini supplier, Nityananda Sahu?
No, Mala, I am
Pavitra
the night brothers man.
At page 133 minutes,
And
at
the night
serial
brothers.
number 5,
You are 7.
Naik brothers,
Night brothers.
7.
7.
7. So you are in CMC unit 2
2.
and he is in CMC unit 1.
CMC 1, 2. Both.
Both.
Yes.
So,
And minor in 13 also he has applied. And give block and Chodar municipality. 4 unit he has applied.
yes. Where is say minor defects? Where do I get it? Minor mistake. You are saying prayer.
But you will find at page 144 minutes. It starts from the middle after the table.
Yes.
During the course of scrutiny of tender documents with original papers of bidders, it is found that the following irregularities seen in some
cases.
Thereafter, Miller, in view of the above point, the district tender committee unanimously decided to allow for opening of price bid, considering healthy competition due to minor mistakes.
Yes. So he has not said that whether Sahu has committed any minor mistake. It is a very general observation.
General.
My lord, I file my objection to annexure 2 euros mechanism.
Yes.
The bidders who are disqualified, I file my objection. Annexure 2, page 108. I'll take my minor's attention to page 139. Then the OP number 5 is there. Declaration form. Though he has applied 1 for 39 page.
Yes.
Though he has applied for 3 units, my lord, but in the declaration form, he said that I only applied for 1 unit, my lord.
Suvendu Sahu.
Yes, sir.
CMC 2 Cutter.
CMC 2 Cutter.
He must have given a declaration for each. It's separate.
No,
For 2, for 1 separate.
No, he must do declaration. He has to say, my lord, in which is a unit has to apply. So he has to mention 3 units, my lord. CMC 1, CMC 2, municipality, Chodar municipality. So this is the answer.
So has he been considered for any other one, or it is for all? He has been considered for 2 only.
No, my lord, my instruction.
CMC 2 only or more?
No, he has been selected more, my lord. So
Where do you have stated?
I have only stated my paragraph that for CMC 2 he has been selected, my lord.
So he has given a declaration for CMC 2.
But my lord, the form said, my lord, you have to mention all the units you have applied.
No,
Yes.
no. If that means if he has not given a declaration, that his tender will be considered for CMC 2 only. It cannot go for CMC 1 or CMC 3.
Then my consistent tomorrow my lord instruction. My instruction that he has already got 2 and 3 units, my lord.
So where you have stated in your petition, sir, you must state in your petition what instruction. When you drafted, you did not.
My lord, on 20th, my lord.
Is there any bar that everybody has to apply for entire? If one can apply for only one, there's-
But my lord, he has to mention in the declaration form, he has to.
he has said that I have appointed as he says that CMC 2 only.
No, that is the form, my lord. It does not.
Yes, he has appointed as level such and such and have mentioned this matter as indicated below against each unit or district as indicated below. It is only in respect of CMC 2.
No, my lord, take my attention to the form, my lord. There is tender document, my lord. It is at page 78, 36 says, my lord. You have to mention all the units you are applying.
What? Sir, first thing is, has he applied for all or he has applied for only one, CMC 2? Where is his application that he applied for all?
Yes, madam. Madam,
Where?
can you see Annex 3, page 133?
143.
43. Yes, ma'am.
Show us.
He has applied for CMC 1, CMC 2, and Tangi block.
No, where do I get it?
Madam, page 43.
That may be a wrong on their part, that his name is appearing in all.
No, madam, he participate in 3 units, madam.
No, so far as CMC 3, no, his name is not appearing here.
CMC 1 and CMC 2.
Correct.
Yes.
His name appears in CMC 2 and in CMC 1.
Then madam, next page 144. Serial number 30. Tangi block and
Yes.
Chaudhar municipality.
Correct.
So 4 units he has been applied, madam.
He has applied only in 3. I couldn't get his name. So far as CMC 3, his name is not there.
No, number 3. 1, 2, and Chaudhar municipality.
Correct. That's all, only 3.
Only 3 has applied. And the tender stipulated that he has to mention the where unit he has applied, my lord, page 78. That is the part of the tender document. I'll take my attention.
78.
78. That is the format, my lord. Name and location of the unit, district, whether you have applied, appointed, would mark 1, 2, 3.
So he has applied in only CMC 2. That's a mistake on their part. His name is appearing in CMC 1, but he has awarded in CMC 2 only.
But my lord, he has applied for 3 units, my lord.
Where do I get an application?
Unnecessarily, I'm not clear to your lordship, my lord. It is a tender committee document lodgement. He has applied.
What do you have to say? Take instruction and come back. 2 weeks. Next.
Item 14.
Well, this corporation is a party, my lord. I think corporation.
Notice on corporation.
Item 14.
This item number 14. Now I have the instruction to appear for opposite party number 6. Please copy of the resolution of this.
Copy. Monday.
Eight, man.
8. Yes. Odisha Mining Corporation. Yes. Would you like to appear in that? Would you like to appear in that?
Yes, it minor direct instruction.
No, other panel council are there, or you are
I can appear.
You can appear.
But the other side is, where is the item number 8?
He is sitting. Mr. Council. Yes.
Give him a copy.
No. Please.
Give him a copy. We are keeping this matter on Monday. Take instruction. Item number 8. Then Mr. Sachin record his name, who normally appears for this corporation. Yes. Take instruction. Come on Monday. In this matter.
Item 15.
It's a very short matter.
I'm very apprehensive of short matter
So what I mean to say.
because of my bitter experience both on that side of the room to this side of the room.
We are always lightened by that, Your Lordship. So the whole thing is this, Your Lordships. There was a tender, Your Lordship, find that at page 20. Lordship, date is 2/7/2025. Last date of receipt of tender was 31/7/2025. Last date for opening the technical bid was 1/8/2025, which has happened. And Your Lordships, there were a series of people who had deficiency like ITR deficiency, labor license deficiencies, and orally they were allowed an extension, orally, without any correction or nothing, that you may fulfill this deficiency. We immediately filed our objection to it. What they have done is neither they have considered my objection and neither are they finalizing. We have a feeling that either a back.
Who is for the other side? Who is for the other side?
That's CORAM. That's notice has to.
Yes, go. 2 weeks.
Well.
Next.
Item 16.
All
What interim? Nothing. They have not finalized it. If they finalize, we'll come.
along with IA,
Yes,
you
you
find
bring. Yes, next.
3.
Item number 16.
3 workings.
On 16, I am submitting a copy of Mr. Maharana is kindly created.
Is why you did not serve when you knew it that he has filed a caveat.
Not another.
No, sir. And 48 hours, that's I know should be given to them to take instruction. Monday, take a copy and come on
I
Monday.
have already served the
Copy of the pursuant to the caveat laws by the opposite party number.
Yes, but item
He's appearing with.
yes.
He appearing with Mr.
Yes.
Yes.
Item 17.
Well, it's item 17. I'm on video conferencing. Well, here we are challenging the letter of termination of the petitioner. Well, that is at annexure 11 months. The main reason for terminating our contract is there has been a shortfall of lifting coal, Malots. Malots, from 2024, we have been writing to them that your coal is of inferior quality. They give us a show cause also, which is at annexure 9 at running page 261, wherein they say that why have you not lifted this amount of coal as stipulated in the agreement? I am placing the show cause, my lords. Annexure 9 at running page 261. Dear sir, the level of your lordship gets annexure 9.
Yes.
Dear sir, the level of lifting of coal in FY 24-25 of Sri
Is
Jagannath
less than 30%. Is less than 30%.
less than 30%, to which I give my reply, which is at annexure 10 at running page 262. We received your notice regarding termination of the, in response, we would like to bring to your attention that the reason for not lifting the material was the inferior quality of coal supplied by your company, MCL, which did not meet the specifications mentioned in the FSA. Despite a repeated communication, the quality issue was not resolved, leading to our decision to halt lifting. Given the circumstances, we request you to consider our situation and kindly arrange for joint sampling within 15 days in the presence of the representative
Who's
of
for the other side?
Notice to go.
MCL Malot's notice has to
Mahanadi Coalfield.
Malot's notice has to
Notice.
oblige.
Next.
Malot, I have just one request, Malot.
Yes.
Malot, in item 11 my lords, I'm sorry, 12 my lords. There is a similar matter that
We'll
3
consider,
times
we'll
is
consider, we'll consider. Don't worry. You
that
give a
may be
notice and
attached
come.
to that matter.
Let us see, let us see.
Yes,
Worry, you give notice and come back.
Item 18.
we have an interim prayer here, my lords.
Anyhow, lifting cancellation is done. Yes,
Bank guarantee invocation may be stayed in this
yes,
case.
yes. Let us see, let us see. Come after that.
Item 18, sir.
Monday.
Yes, my lord, the pursuant to tender invited by the Central Cooperative Bank, Baleswar. Last September, his bid was accepted and directed petitioner was directed to deploy his manpower on 3rd, my lord. 2nd September, my lord, so cause notice was issued that he was previously blacklisted and terminated to file a reply. My lord, on same day I filed, the blacklisting period is for 1 year and the termination was already stayed by the Honorable Court. On my lord, next date, my lord, they have cancelled under clause 33, your lord.
Where is clause 33?
Your lord. Your page 23.
Page?
23. Page 23, answer 1, your lordship.
Clause?
33, your lordship. The agency should not have any criminal antecedent or / previous unsatisfactory service report previously blacklisted by any organization. And your lordship, the impugned order annexure 8, your lordship. Page 87. In a single line, without any, I have filed a number of my case and documents paragraph, 1 line, your lordship can see that. We are after selected as a L1.
Who is for the other
as
side?
per the tender condition, technical.
Who is for the other side?
And successfully put our opinion over file.
Oh, whatever, sir. Let us see that whether this clause is consignable or not consignable.
Lordship, again, I'm reading clause 2 on 33, Lordship.
It is a perennial, sir. It is eternal. That even if he was blacklisted 40 years before, he will be deprived of participating in any tender.
Blacklist is not never.
That's the order.
Blacklist, Lordship, kindly see. I have the copy book because, Lordship.
Because it says previously blacklisted. It does not talk about.
But, Lordship, kindly see clause 33. I have the documents, I supplemented my affidavit. Lordship, kindly see clause 33 once again, Lordship. The disqualification not confined to blacklisting, Lordship. It also, Lordship, prior to that another clause, the previous unsatisfactory service report. Lordship, he is not blacklisted once, Lordship. He has been blacklisted by number of departments, Lordship, and unsatisfactory reports by giving terminal contract, in some cases not giving EPF, not Lordship filing manpower to the supplying manpower, and the blacklist not in one issue, Lordship. In number of company departments, they have been blacklisted. So they have been considering as a whole, Lordship, considered a whole. So, Lordship,
What is the ground for cancellation?
they have taken
It is before us.
My lord and senior adding more than the impugned order.
on my complaint with that is not, then I can supplement my affidavit that on my all the participants, Lordship, made a complaint against him because he's a habitual Lordship, is not blacklisted by one department. By number of every department, Lordship is blacklisted. Not more than 3 departments blacklisted. And Lordship, the more Lordship.
Has he disclosed anything?
Lordship, on the face of the document, that is not what our complaint petition.
You have said received some complaint from the different sources that have provided deficiency of service
and
have previously terminated and also blacklisted.
So for deficient service, Lordship, that is
So clause 33, your tender is cancelled. Have they given them any notice that you please clarification?
Yes, sir, they are clarified.
Where is that notice prior to 5/9/25?
Yes, Lordship, he has given the reply also, Lordship.
Where is that?
Lordship, his own amendment, Lordship, in the reply.
Yeah, I have annexed.
His annexed, Lordship, he has given notice and his reply and consider the steps, Lordship.
Where is the consideration?
Where is that?
Your lordship, annexure.
Where they have given you a notice?
Annexure 5, page 43, your lordship.
They give you a notice?
Yes, your lordship. After the stage of your lordship can
Page 43.
Just.
Your lordship.
Just.
Yes, then what you responded
And
to?
it's a 6 page 15 words. We have annexed the order of this.
Yes.
point, including blacklisting order. I annexed.
Oh,
Sir.
what do you mean by blacklisted?
Yes.
Your answer is very, very vague. What do you want to say?
The page 65. I have annexed that order also, which is part of my reply. This period is also ever page 65 plus. It is blacklisted on 10th August 2020 for a period of 1 year. And it is already period is over. This honorable was and remanded by the OMD. Page 65 plus. Which is decision. This decision they are not yet blacklisted. It is passed. At present of submission of bid, there is no blacklisting order. And this period of 1 year also. And the
Where is the ultimate decision? That it is quashed.
Yes, paragraph. Let's 20 page 80. Paragraph 20 page 80. Same answer.
Quashed. So the blacklisting order goes. And the matter was remitted to the authority. Has he taken any decision?
No, sir.
So there is no blacklisting order as on.
Replies, Lordship. He has annexed 2 blacklisting documents, Lordship. He's twice the different departments. And Lordship, kindly see, if Lordship consider the second, the main qualification of previous unsatisfactory service report.
Sir, it has said that there is nothing which has come out, and the entire thing which at one point of time was flagged was subsequently resolved by the authorities. There is no certificate which is issued that there is an unsatisfactory event lasting on that day. He has given, yes, because they immediately decrease the remuneration. And that was the reason they approached the court, and the court has stayed the order. Secondly, they have said that so far as the EPF part is concerned, because many of these outsourcing personality, they did not provide an Aadhaar. That was given, subsequently it is resolved, everything has been paid. And the authorities have not taken any steps against them for that.
But let's kindly see the list of 2 departments.
How can you do it in this way? If they have given a reply, who is there?
The bank, Your Lordship.
Bank to reply.
No, bank to.
Orders for Gujarat Central Court.
If that being the position, then in that event, can't be. Can't be. When blacklisting order is caused by the court, then there is no subsisting blacklisting order.
Not blacklisting, Lordship. Apart from that, there are various concerns, Lordship, and notice. He has not given EPF, Lordship, to the employees.
Sir, that he says that it was not because these outsourcing personnel who will outsource did not provide an Aadhaar card. And unless they provide an Aadhaar card, it cannot. They reported to the authorities. Subsequently, their intervention, Aadhaar cards were given by them, and then they deposited the entire amount, and there is no grievance. So far as a provident fund, the employees' provident fund authorities are concerned, they have not raised any demand. The grievance. He has complied.
Lordship,
At one point of time, what
Not
can
standing on the way, Lordship.
Sorry.
My simple remarks, Lordship.
Sorry,
In the
you
meantime,
can't.
That has been awarded to me, Lordship.
Sorry, that is illegally awarded to you.
Lordship, that is another Lordship.
Sorry.
They have created another cause of action, Lordship. I am
No, it's not a cause of action.
No, Lordship.
Their cancellation has to go. Their
Lordship,
cancellation order, if their cancellation order goes, what would be the fallout? Tell me. I am asking you. Sir, you are a veteran lawyer. They are challenging an order of cancellation of their contract. If this cancellation order is set aside, what is the effect? Tell me.
No, Lordship.
Then what is the effect? Tell me.
Lordship, definitely, Lordship, that.
Then in that event, nothing.
You know what they have done, Lordship. Just I'm applying.
Issue notice, and no further steps on the basis of that. Sorry.
Lordship, they have ordered to others, Lordship, not to me also, Lordship.
Sorry. We can't.
1, 2, you are appearing. 1, 2. Opposite party 1 and 2. You are appearing. Register cooperative society.
The entire
3,
Lordship, they have
and
given
4,
they have ordered to others, Lordship, not to me also. No, they have selected me.
4.
But the others are party.
No, he has not made party to others.
Work order issued to 5. I have annexed the work order.
They have given to me also, Lordship.
Annexure 6.
They have not given the work to me also. Now the file has been, Lordship.
So the contract has not been awarded to anybody.
Annexure 9. Annexure 9 is the issue to you.
RBI separate.
Separate. They are separate.
So 1 and 2 you are
1
appearing.
and 2 I.
3 notices to go. 4 notices to go.
5 also.
5.
Mr. Dali.
Yeah, you are appearing.
So the 8th September was the order. Have you deposited that 5 lakhs rupees?
6, 8, 7.
You are Bimal Raj outsourcing?
No.
Yes. Copy number 5 is Bimal Raj.
I am Bimal Raj.
That is what I am asking. So work order has been issued to you. Have you deposited 5 lakhs rupees? That was within 8 September.
Let's write update.
And whether any agreement was executed?
One possible.
Take a instruction otherwise.
Just one possible. Okay.
The tender call notice Come in the morning tomorrow.
Item 25.
This matter, my lord, on the last occasion, when occupant asked me to do some homework regarding the maintainability of a writ petition, which is filed after the statutory period of limitations is served. So, Marches have given me the guideline of GlaxoSmithKline. GlaxoSmithKline is written by paragraph 19. And only Honorable Prime Lord, if the Lordship will grant me some more time, I've come across some judgments, but there is still a lot of gap.
Whatever.
So I'll try to convince your Lordship because they are.
You can well imagine the pulse. Do it.
It need be the
How much time you have?
think after vacation we have
Notice. 2-3 days after.
My one second. Item 26.
vacation we have
Notice.
the advocate Prime Lord 26 is also a similar matter. Of course,
Item
I do not have
26.
authority to.
My lord.
Notice.
The advocate Prime Lord need not allow because it's similar, but I would only frame lots because I'm
My
not
lord,
here
my
to that case. So this will have a far-reaching consequence. Lordship judgment in this it's similar, but I would only frame lots because Lordship will have a far-reaching consequence.
Okay.
That's what I'm saying. No, subject to what my friend Mr. Tas.
Come on that day. We'll hear both. Don't.
27.
What I'm saying. No, subject to
My
what
lord.
my Mr. Tas.
27 as well. 27, my
My
lord.
lord, we appear for
Two at a time, we can't concentrate who is appearing in what matter.
My lord, 27 as well.
My lord, we are
I'm not there in 26 months. I'm not there in 26. But the question
Yeah.
of law, my lord,
Who is it? Let us see. That's why it has a larger
larger
impact.
effect, my lord.
We are keeping this matter so that at least we can have.
And my learned senior,
Yes.
Mr. Sahu, would be also joining.
Yes, yes.
And I've also requested Mr. Sahu, he'll be joining us with this matter.
Yes.
1074. 1074 issue. The limitation. Outer limit fixed in a.
Because one judgment is cited, we want whatever. Glaxokill matter. Matter is
Item 33 of my lord and senior Sahu. 33 is also the same matter.
I have also one matter.
Item 33 may be tagged.
so 26 you are appearing.
Yes.
So it's better we are keeping as he requested.
Item 27 as well.
26 who is appearing?
My lord. My lord.
Keeping as he requested.
Item 27 as well.
26. Oh my God, I can't. That's the irony of the virtual hearing. Sir, we are in 26. So anybody who is appearing in 27, please just have a patience. Virtual hearing. Sir, we are in 26. May I know who is appearing? I do not know.
I'm appearing for opposite partner one in.
Now, who is for the petitioner? I just wanted to know.
Mr. Biswajit Das? Mr. Biswajit Das?
Your Lordship, my name, I am for the petitioner side.
You are for the, so
Advocate Deepak Kumar.
you are appearing in 26 or 27 both?
Sir, I am appearing for both 26, item number 26 and 27.
Yes, there is one issue which is raised and we wanted you to assist the court.
Sir, Your Lordship, we need some time to finish our research on this
Yes,
matter.
please do it.
And,
We are
sir,
keeping this matter
I
2-3
need
days.
adjournment and I
Please
need
have
some time.
2-3 days after the vacation. We are fixing those matters.
So 25, 26,
25, 26, and 27.
33.
Your Lordship, if Your Lordship may grant a short date for this matter because we need some
Can
time to
you
research.
argue? Have you seen the Glaxokill matter, the judgment of the Supreme Court?
No, Your Lordship, we need some time to research on
Yes,
this.
that is what I say. That judgment is staring at our face, which really affects the maintainability of 226 application.
Yes, Your
So
Lordship.
please come. We are fixing the date 26 and 27, both on that day. Your counterpart has raised Mr. Prashanjit Mahapatro has raised this issue. So let us see
what can be done. Yes.
Much obliged, Your Lordship.
13th October.
Huh?
13th October.
13th October, we are fixing that.
Much obliged, Your Lordship.
27 also I beg to assist your lordship.
Yes.
Yes. 27 also, we are fixing that matter.
Lordships.
Item number 28.
28.
Lordship. Lordship, during the previous occasion, Lordship has asked us to file a supplementary affidavit, which we, Lordship, we filed it. The short
What is that supplementary
question,
affidavit?
Yes, Lordship. We have filed it, Lordship.
When?
Lordship, on Monday, 15.
We have filed
Flag,
Lordship.
Have you got the copy?
Yes, my lord. It is at flag D.
I have also brought further instruction, further information. So further instruction, so far as the confirmation, I have also brought the short for the confirmation from GSTN, Your Lordship. And GSTN has clarified that the notices as well as the order all have been uploaded in the portal, and that is in the dashboard of the petitioner, Your Lordship. This is the confirmation
No,
of
Lordship.
the GSTN, Your
Lordship, I beg to
So far
differ,
the
Lordship.
dispute regarding ASMIT.
Lordship, I beg to differ that. In fact, last time the Lordship has pointed out this point that can they upload today? Lordship has last time also apprehended that point. Can they upload today?
Mr. Counsel, what we are saying is that was it uploaded earlier or it has been uploaded subsequent?
Yes, Lordship. No, it has not been uploaded, and for that, Lordship.
But he says that it was already uploaded.
Uploaded.
No, Lordship.
Everything. Your Lordship, you have kindly turn to.
Yes, show us
It's a copy of it.
that information.
Your Lordship. Page 6, Your Lordship. Directly, Your Lordship can.
Lordship, my Lordship, my humble submission.
I have
Lordship,
short
my
form
humble
in this
submission.
mail that is started at page 4. Request for verification, Your Lordship. Page 4, we have requested the GSTN for clarification. Page 4. Then they have clarified at page 6. GSTN has clarified. Form issued DRC01, email ID, IDT, so and so, timestamp 30th/10/2024, so and so time, email content, Ola Free Technology, notice has been issued by reference number so and so, reply regarding determination, you are directed to furnish reply by dated so and so and appear dated so and so. At 11 city, you can view, download SCN from GSTN portal below path. Status of your proceeding is available in your dashboard. This dashboard. It has been uploaded in the same day, emailed Your Lordship through this mail. And the second DRC01, mobile number so and so, timestamp 30th/10/2020.
So let them take an instruction that what they have disclosed today, take an instruction, because if it is not there, then you'll have to counter it.
No, Lordship, just small point, Lordship, I would like to mention. In the petition, page number 34, Lordship, I put a screenshot.
Yes.
Of the GSTN portal. Page number 34, if Lordship can see that.
Yes.
Where it says no record. Okay, the Shoko notice, no record. Hearing notice, no record.
Page 30?
Page 34, Lordship, of the petition, annexure 4 of the petition, the main petition, Lordship.
No records found.
No record.
Yeah.
And page 35.
Now that is what you say, that no records found. I understood, but now they are coming up. Now this is what the dissent comes.
Your Lordship,
Lordship, kindly see page 35 also.
How to decide it? How to decide?
Lordship can send us back. We are okay. Lordship can send us back. We are okay. Let them give me a proper service of that. We can go back. But the point, what they are trying to make, and I'm very.
What is your reaction to this page 34? What the authority has said about page 34?
Your Lordship, page 30.
Mr. Mishra?
Your Lordship, page 30.
It says that no records found. And this is I think, a screenshot which they have taken.
And 35 as well, Lordship.
If it is your system.
Your Lordship, portal is that.
Correct. Whatever the portals are,
You have uploaded in the portal, you say dashboard, everything is flashed. So one can only access through this portal. And if he says that there is no record found, then what? What happened to the record if it is already uploaded? Where is that record? So you'll have to take positive that this is what.
Your Lordship, only I am submitting your Lordship.
Sir, this instruction,
Your Lordship,
you have not verified properly.
Your Lordship. What
Mr.
in my portal, in my back office, it is shown, it is reflected.
So that is where the problem lies.
For that reason,
You can see certain things which other parties do not see. That is the indication given at page 34. That is the instruction you are required to.
From that reason, we have sought clarification from GSTN because that is the third party.
Whatever.
That is
Then why have you sent this?
Everything uploaded, everything you are saying, and they are showing that there is nothing on record. The records are missing. Records are not found.
I'm not disputing your Lordship.
It's not found.
Only it is my portal. It is shown. It is
Maybe you can have an access, the other
For
cannot.
that reason, I have sought confirmation from GSTN. That is a third party who is control over both the portals.
And last paragraph, he is admitting certain anomaly.
Yes, that I am considering.
The last paragraph.
That I am considering, Your
So,
Lordship.
there are certain anomalies
Also,
in uploading.
Your Lordship, that I am clarifying.
Then why are you in affirmative saying this all?
To go to assessing officer, Your Lordship.
You should
I'm not
Where
going to
to the bench, sir?
Your Lordship may remand the matter.
Your authority has not seen this. Has he gone through each and every document which is enclosed to the writ petition and replied to you? Whatever he is seeing, he has said. What about the other side? And you have proceeded against him, prejudicing his civil rights. And you are arguing.
Your Lordship, while Your Lordship, I am considering only one part.
No, unless you bring forth what is this the record not found?
Let me consider one part. In the year 2021, Your Lordship may kindly turn to page 3 of this instruction. This is also a fault in the assessment order. Your Lordship, in 2021, 2/7/2021, an ASMAT 10 has been issued. And the colleague for his reply, ASMAT 11. He has not replied. Subsequently, in 2022, another ASMAT 10, that proceeding was there. Another ASMAT 10, in order to provide natural justice, another ASMAT 10 has been issued, and which he has replied. Pursuant to that reply,
Kindly appreciate, Lordship.
I'm conceding, sir.
No, let me, Lordship.
I'm conceding myself. I have done, my officer has done the mistake in the assessment order. I am conceding on your part.
No, but let me point out, Lordship, what my learned brother is saying, ASMT 10 into 2021, which is the last number is U, and ASMT 10, which is on this 30th March 2022, which is last is Q. Now we have taken total credit of 26 lakh.
Sir, there is the instruction. Sir, instruction copy is not with you. That's the whole ticket. He has said that there is a liability mismatch. There is an ITC mismatch also there. He is conceding that there was some fault which was committed by his officer. And it appears that there has been some lacuna. There has been some discrepancy in the order. What he wanted to say.
If
Your additional affidavit I am placing, you have taken the ground. So, in order to future complicacy, Your Lordship, what happened? 22, I have issued another ASMAT 10, Your Lordship. And consequent to that, Section 73, DRC 01, reminder, and DRC 07 has been done. While making the assessment, Your Lordship, so far as 2022 DRC ASMAT 10, consequent to which, Your Lordship, on the last occasion I have pointed out, in assessment order, your authority has said that no reply has been filed, and your instruction, you are providing that. My Lord, Justice Raman, question that.
No, Lordship, just small point I would like to mention, Lordship. In 21 ASMT, they have issued, which we have not replied because that was saying the demand proposal was 27 lakh. 22, they have issued a ASMT, another ASMT 10, which we have replied.
This is what he is admitting. And to that you have given a reply.
Yes, Lordship.
And he says that how the authority can say that there was no reply.
Yes, Lordship.
So he's admitting that. That's a mistake on the part of the authority.
Your Lordship. So in the read petition, Your Lordship may kindly turn to page 20, the part of the BRC 07, where this 2021, where he has not replied, that has been reflected. So for the 2022 ASMT 10, consequent to which this proceeding has been completed, that part has never been narrated in the assessment order, adjudication order.
Correct.
That reason only, Your Lordship must set aside the matter. Let them comply whatever they want to comply. Let them comply, and the time-bound manner, within a time-bound manner, Your Lordship may fix, and Your Lordship, the assessment will be completed.
Correct.
Yes.
So now you have anything to say?
Just a passing, just a small observation, Lordship. Even 22, what the ASMT 10 they have given was saying the demand of 25 lakh. But ultimate, the Shoko notice has come proposing a demand of 19 lakh. So far as 19 lakh rupee matter, there was never ASMT 10 to us.
Sir, let me
for 19 lakh rupee matter, because
Shoko
Shoko notice has come.
Clarify. My Lord Senior is senior.
Shoko notice has come for 19 lakh.
Kindly
For
turn to
19 lakh,
section provision
there was never
16.
any ASMT 10.
And provision 72.
They are having different ASMT 10. How do I know?
ASMT 10 has no relation with the proceeding under section 73. That is a separate proceeding.
Under section 73, they need to issue me a notice. They are not. And there is not even a single averment from them.
So the entire order, he says that should be caused and remitted to the authority to do a fresh exercise, and you may be given an opportunity, whatever you wanted to say, let them give. This is what he says. Once the order goes, then what remains? Now it is open to you to take whatever defenses which is available to you.
Yes, Lordship. We will
take
be
that
obliged.
defense.
We will be obliged.
Yes, brother.
What may respectful submission, Your Lordship, time-bound manner, Your Lordship.
Oh, obviously, sir. And we will also ensure that he does not indulge into the protracting the litigation. He should appear before the authority, assist and cooperate. Whatever he want to do, he will not ask for adjournment.
No.
What more?
Good.
What is the
My humble submission is, Lordship, the festive season. Festive season is coming up.
complete the exercise?
Lordship can give little space on the festive season.
You can do
little
it
space.
within
I'm
2
not saying
months.
2 months. Yeah, 2 months will do that.
You can do it.
Yes, Lordship will do that.
No, not you. I'm asking the revenue department, GST department.
Your client is ready, Mr. Mukesh?
2 months.
Yes.
Sufficient.
Yes, pass. Yes, 2 months, you do it. We are giving you an opportunity to respond, whatever, and give your defense, and then within 2 months, everything will be done.
Obliged, Lordship.
Yes.
What is the date on which your client can appear? Can we fix a date?
Lordship may fix any date as per Lordship.
Don't fix a date because of
Anytime after Diwali, Lordship can fix. Anytime after.
Why Diwali? Diwali is 1 month. More than a month. Sir, Diwali is more than a month. After.
On 15th of October, Lordship.
No. Yes, 2 months from date.
From date.
Yes, 2 months from date.
From date.
Yeah. From the date of submission.
No, from today.
Provided against to.
No, I was telling that whether he will appear on a particular date. On that date, he will appear along with.
So we don't know the authority how he's placed. So it is, that's my view, not desirable to fix a date here, but otherwise that will create a burden on him.
3 months.
So it is 3 months. Okay. From today, 3 months. So Diwali, he will enjoy.
2 months.
No difficulty. 3 months.
if your lordship will not fix any date on the last day, they will go and
Second copy of the idea.
Yes, 3 months.
Well, item 29.
Applies.
I humble submission, regard. The last occasion, I was directed
To take instructions.
to take instruction,
Yes.
I have taken, regarding the centralization of jurisdiction and transfer of cases under section 127.
So the principal commissioner, Visakhapatnam has power to.
Power to
Yes.
France. Jurisdictional commissioner.
Keeping in mind section 127, one. I have one. This circular only says because centralization is applicable not only to such but not such cases. I don't know how this supports the case of my friend.
Subordinate to.
That one has to be subordinate.
Right.
Then another is after hearing.
Two main conditions. That's one recording reason and giving opportunity. Yeah.
So that, that has been given, that is objected, but means the RCC has objected and that has been set out by the department.
By this?
It's like,
By this?
no, not by this. That is for jurisdiction, centralized jurisdiction.
No.
That time after my recent file.
He's heard.
That is supplied.
Has he been heard before transfer?
No, the reason for transfer of the cases.
127.
So how can it be? What reason has been assigned?
Well,
the order which is impugned, does it contain any reason for transfer? Where is the order? Which page is the order?
Based on, that is in order, fully notice transferring the case to us at the election 8 kilos. At page 90.
Yes.
90. 90 kilos.
Nothing has been given. Only the invocation of 127.
When the prime accused in this matter,
Mr. Mahanti, have you considered this provision as your authority? Considered this provision and acted according to the provision of law. This circular itself shows the above mentioned the guidelines do not deal with centralization or transfer of non-such cases under section 127 of the Act and are not intended to preclude centralization of non-such cases in any manner. Having said so, this is a case of such. This is a case of such. So it comes within the fold of 127. Whether 127 ingredients are being passed.
Followed.
It is only notice that we issued for the central jurisdiction, my lord.
Sir, what are you talking about? Come to paragraph 2 of the notice.
Yes, madam. Therefore, in accordance with the provision of section 127 IT Act, you are requested to submit your objection.
To whom? To whom? To whom?
The petition, madam.
No. Submit the objection before whom?
You will issue the notice, my lord. And he has already replied. He has already replied to that notice, my lord, in page 92, my lord, in annexure 9. My lord.
He has already been directed to submit to the jurisdiction of the DCIT Cuttack.
Principal CIT Central Visakhapatnam. Your case is to centralize the DCIT Central Cuttack. And then he says that
at the time of transfer, who is to hear? Who is to issue notice for hearing? Who is to record the reason for transfer? Sir, what does this law say? The person who transfers, he is to hear or not?
Yes.
Then who has given notice to him for hearing? Who has recorded the reason for transfer? Please explain, sir.
It is a notice sent.
Sir, who has issued notice of hearing for transfer and to whom he has given the reply?
It is by the Sambalpur.
From there, you want to centralize it with the DCIT Cuttack. Correct.
Yes.
Now, both are within the state of Odisha.
Yes, ma'am.
Visakhapatnam is also within the state of Odisha, I believe.
No. Sorry, so sorry.
Sometimes the sarcastic things should also be.
No, well, this is.
It is. So, in that event, subsection 1 of section 127, what it says, who can do it? A principal director general, or a director general, or a principal chief commissioner, or a chief commissioner, or a principal commissioner, or a commissioner. These are the authorities. What it says, may, after giving SSC a reasonable opportunity of being heard in the matter, wherever it is possible to do so, and after recording his reasons, two twin conditions, personal hearing and recording of the reasons for doing so, transfer. So these are the authorities who can transfer any case from one or more assessing officer subordinate to him, whether with or without concurrent jurisdiction, to any other assessing officer or assessing officers also subordinate to him. So if he exercises the power, say of the entire state of the Odisha, then any assessing officer would be regarded as the subordinate to him. So there is no difficulty that he can take away from Sambalpur, which is within the state of Odisha, and then put it into a Cuttack, which is also within the state of Odisha. Both assessing officers are subordinate to him. Can these officers who are named there of the another state direct another assessing officer who is not subordinate to him to transfer the case to another assessing officer who is also not subordinate to him? This is the first thing which happens. To make some kind of a adjustment. But that adjustment says that there should be an agreement with those persons. Nothing has been done. Your first sentence is that in terms of the order of the CIT, principal CIT, Visakhapatnam, you are directed to appear before whom? DCIT Cuttack. That means where they propose to transfer and he's submitting to the jurisdiction of a transferee by virtue of this notice. Before you could record your reason, whether it is a fit case for transfer, whether opportunity of hearing is to be given or not, before the transfer order is given, you have already done it. What he will go in there? What he will do? I'm just asking you. If he goes to the DCIT Cuttack, what he will do? Can he take a decision that no transfer to take place? It will be done by him, whether the transfer to be done or to be effected or not. So it is he who has to take a decision. And once he took a decision, yes, transfer, no difficulty.
One more thing, Your Lordship, kindly mark. Request submit your objection, explanation, clarification, if any, regarding the centralization of case with the DCIT central Cuttack by such and such date. Your compliance should reach Office of Principals,
Sambalpur.
On such and such.
Oh, I have seen so.
Right, sorry.
So what they are directing is that they wanted you to submit to the jurisdiction of the Cuttack, where they proposed to transfer.
Correct.
So once you submitted to the jurisdiction of a transferee, then what remained?
And prior to complying 127 to requirements. This is a consequence of. No, without complying 1.72. Supreme Court and two judgments are there. The other day I was showing by also.
What more? This can't be done. How can you?
to further instruction.
Whether you have adhered to 127 strictly.
But the question arises whether the principal commissioner of Visakhapatnam has the jurisdiction.
True, true.
So you explain
Explain.
that
Has he?
whether these two ITO or DCIT and ITO, they are subordinate. To whom? To whom he has to reply? Transferor or to transferee? Who is the transferor?
Visakhapatnam.
So with whom he will lodge his objection?
No, this objection raised, that is compliant.
Where is that?
That I will. So he has already replied to this.
Where is that?
92, page 92, my dad. Page 92.
Connection 9.
Connection 9.
My friend is referring
To whom he has replied? That is what we are asking you. To whom he is required to reply.
The income tax officer Sambalpur.
Why? Is he the transferor? He will object to the transfer. With whom he will lodge the objection? To the transferor or to transferee? Or any other person who has not initiated the action for transfer? Is that section 127?
As per this reply also questions his jurisdiction and also non-grant of reason, both the conditions you are that is pointed out, please reply.
Well, I will take the instruction against the reason, whether it is with, from the PCIT, I will append that instruction.
First of all, in writing, you have to have a reason, then opportunity of hearing, consideration of his objection, then transfer. And you have to look to your own jurisdiction, whether you have the jurisdiction to transfer or not.
Your Lordship, I received the last order passed by your Lordship.
We have seen that.
My Lord.
2925 order.
Yes, 2920.
Very specific.
Specific.
Very specific. See.
It strikes, it goes to the root of the matter. You may have a very good case on facts, but once the jurisdiction point is raised, then that has to be decided first.
And my humble service one submission. And in case of search and seizure conducted under section 132, right? So I don't know why the
Does it overpower? Just tell me, 132 overpowers the provision of 127.
No.
If it does not, and then once you invoked 127, irrespective of the nature, you have to justify that you have taken recourse to all the rigor of 127.
I will submit before also.
What
submit? You have submitted already.
No, my lord, I submit the
Sir, if you come to page 90 Annex 8, subject. Annex 8.
Annex 8.
Subject.
Proceedings under section 127.
So, you have to justify your action that you have complied with the modalities or the manner in which it is provided for.
Yes, ma'am. I'll tell the instruction.
That is what order dated
2/9.
2/9 is.
Yes.
At your behest, time was short.
Right.
Price of 4 times, I think, different than 2 times. I work. Anyway, just time.
So that's why Mr. Venat, department has not supplied that whether the PCIT hijack the research. There is a notification that it has not been. I think they are they are not supplied.
Then why have you opened your queue?
Mine.
Then what notification? You have come with the notification. It does not talk about anything like that. Then you say there is a notification. If you have not seen those notifications, so this is something in the air.
This is also not a notification. Not a notification, it is only a circular or internal communication, you may say.
So don't argue in vacuum.
No. Yeah. And now the portal in the meantime, after taking adjournment time, it shows centralized jurisdiction, central Kolkata.
The entire jurisdiction.
They have already acted upon. Now the portal shows. I think my friends, let him see. You must have seen. The other day I was I have shown to Lordship Bureaus.
Mr. Kadia, have you not instructed your officer?
You have already instructed, no action will be taken.
Then
that has been transferred.
You see, no action has been taken.
Portal, it has been transferred.
First case in central job, who are the central
Not first of all, the case when the search has been conducted under section 132. All the assessment proceedings and who are been involved, they have been assessed by the central jury.
We appreciate it. That may be an ultimate decision that you will take. But before taking an ultimate decision, if there are certain formalities which are required to be followed, will you ignore that?
No.
So we are really stuck up at this stage. You may ultimately pass whatever order which is within your discretion. We are not questioning, nor we are going to question that. That's your decision. But what about the procedure, mandate of the section? Those, you cannot bypass this. You have to adhere. Which I find from subsection 1, three conditions. One is the officers or the authorities who are named therein must have the direct superintendent's power of superintendence or control over the assessing officers, both from whom he wanted to take off and to whom he wanted to entrust. Both must be subordinate to him. Second is, there must be a reasonable opportunity of hearing that should be given. The third the condition is that you should record a reason why you want it. These are the three conditions of subsection 1. If you want to dispense with subsection 1, no problem, you can. Subsection 2 says that if you are not the same, then you'll have to seek an agreement or a consent. All these things are already there in the Act itself. What to do?
Who has initiated the proceeding under 127? Which authority?
Yes, sir. How? Then why the name of the Visakhapatnam?
Why? Where do I get it? It is the Sambalpur who has initiated. Where? It is only you are directing him the objection or something is to be filed before the Sambal. That's all. Initiation is not done. Initiation is done by the principal CIT Visakhapatnam. How can you say? What is the initiation? Just
And do you mean to say that principal CIT Sambalpur is subordinate to principal CIT Visakhapatnam?
No,
I don't know. 127 is that subordinate has to, then in writing, then
reasons.
hearing.
I may be permitted to I think after vacation. I will submit or whether the reasons are recording that
It is merely a protracting the litigation, nothing more than that. You are not been instructed whether the mandates are followed. Secondly, the written record cannot be overridden by an oral record.
Right.
It is a written document which is paramount than the oral instruction. And the first line says that on the basis of a order or a instruction or a proposal by the principal CIT Visakhapatnam. That clearly shows that he was a person instrumental in initiating the process of transfer. If he has no authority, then everything has to fall. If the foundation is removed, castle will fall. What more instruction you will take?
Kindly.
What kindly? Has to be kept at heart. We did not pass an order on the other day, but
May I give a few judgments?
give.
Supreme Court judgment that was followed by Himachal in 2 matters. And 2 matters. Himachal, 2 matters.
Why don't you give me a Supreme Court judgment?
Nice. That is what I mean. Then 11 square feet. Ten, 11 and 17.
That is on a recording of the reason.
Recording of reasons.
No, this stage has not come.
The stage has
After he obtains
proposal to transfer, but the transfer has not affected.
But before doing that, record must be, results must be recorded.
So you are
That
making
stage
him wise.
has not. My brother correctly said the stage has not come.
But Himachal, which refers to other Supreme Court judgment laws, says that twin conditions. Your Lordship says five, actually there are 3 conditions. But Himachal High Court law says that twin conditions, so recording of reason and the opportunity of hearing.
That's they have to. First, they have to justify their actions as per 127. Thereafter, it will come. Now it is.
First of all, that whether Visakhapatnam, that's the root. That's the main issue.
We are on an earlier stage now.
Yes, absolutely.
Whether they have recorded in reason
That is again sub.
Whether who has initiated the proposal
Absolutely correct. Lord.
and who has
So this,
been
this,
vested
this
with the
will
power.
come later on if they pass an order, but
Absolutely.
this is a premature stage.
Correct. Lord. I agree. Absolutely.
Though the challenge is made to a notice. Yes.
This matter relates to multiple financial years single sources.
Yes.
Similar matters are pending.
Yes.
Corrected.
Yes.
Checked up. Verified, no? Verified.
Next.
Item 31.
Make please. Yes, my lord. My lord, in the input order, I was challenging that I have given every documents, my lord, whatever they wanted. Still, my lord, they have proceeded under saying under section 74, saying that the forms are from where the supplies was made. It is not existing, my lord. We have given all the documents stating that their GST registration, everything, my lord. But still, they are coming to a point, and they have admitted clearly in that
Supplier is alleged to be non-existent.
non-existent. Last time they
Your
stated.
Lordship, on the last occasion, your Lordship was directed to take instruction. Your Lordship may kindly go to the instruction, how the entire chain there is a fraud. And all the supplier from the beginning till petitioner. Your Lordship, directly, your Lordship, I can take your
Everything is fraud.
Your Lordship. Your Lordship, 7 crore, 8 crore.
Not even one is spared.
Not only one. How this has been managed, your Lordship may kindly turn to page 6. Your Lordship, for a moment, your Lordship may kindly go through the entire and directly to page 6, annexure B. The supply chain, your Lordship.
Yes.
Your Lordship. Here,
Is what is this? The
this
name
is
of
Amit
it,
Metal.
sir?
This is Amit, the both
Metallics.
Amit Metal and Sriyanka. Both are same supplier.
Two metals tagged here. One is Amit Metallics,
Another
another is Srinika.
Your Lordship.
You are representing both.
Both.
They are purchasers.
Right, they are the purchasers.
Yes.
And from the same supplier.
My lord, what is, my lord, before my lord go into that, there, my lord, page 20 for a moment, my lord, miss. They themselves have admitted, although the taxpayer has submitted documents like purchase bill, e-way bill, payment slips, bank statements, these do not adequately disprove the finding of tax evasion report that the supplier are fake and non-existent. They themselves say that I have given.
Basing on the tax budget, that those are not disputed. Your Lordship, on the last occasion, I have also submitted the
Yes.
documents.
Then.
Your Lordship. So Amit Metallics is the petitioner and the purchases from Swastik Trade Venture, both the petitioners, Your Lordship, both the cases. Your Lordship, Swastik Trade Ventures have purchased from all these funds. Senapati Traders, Oman Traders, Turkey Traders, BK Traders. These particular suppliers, Senapati Traders, 75 crores, 97 without any purchase. And that has been verified, Your Lordship. For the preparation.
75 what? 75 crores means?
78 lakhs, sir. ITC, I'm sorry. ITC availed to be 75 lakh, 97 clear without any purchase. Then Your Lordship, by Oman Trader, this ITC, 4 crore 87 lakh, received from SM Trade, Subham gave, RC cancelled 6/11/2003. ITC of rupees 2 crore 35, Kulchit Singh, GST and RC cancelled from 2022. BK Traders received from 83 lakhs, 8 crores Turkey Trade and Services, and Turkey Trade and Services, Your Lordship. So all the suppliers, Your Lordship, are non-existent, and all the transactions are paper transactions. Basing on this, Your Lordship, a fraud case report, tax evasion report has been prepared, and basing on that tax evasion report, the assessment has been completed under 774. So all these are factual findings, Your Lordship. All these have to be paid, Your Lordship. And for that reason, on the last occasion, I have also paid, since this is 74 assessment order, and it is well within the time. So let him file the appeal, because everything has to be verified. Only once it is not sufficient to submit the tax invoice as well as, Your Lordship, so far as a bill, a voucher, Your Lordship. Because everything has to be verified. Your Lordship may only turn to the details, Your Lordship, in this instruction, Your Lordship. After all the verification, Your Lordship. And Your Lordship, on the last occasion, particularly in this case, all the bank accounts, Your Lordship, the suppliers' bank accounts have been verified from page 7 and 8, and all the bank accounts are invalid bank account, Your Lordship. and no bank account could be valid, against which the money has been transferred. And your lordship, scooter, motorcycle on the last occasion, I have that subsequently slowly that has been said, but only one finding at Annex B, page 9, the suppliers, that motorcycle and scooter, 7 lakhs, your lordship, 7 lakhs. 7,68,900 in Hero Honda motorcycle.
The stigma.
Your lordship. Page 9. That is the supply. So entire same, your lordship, not a single. The petitioner is the beneficiary, is the recipient of all these input tax credit, your lordship. So for that reason, in the petitioner's hand, those have been disallowed, your lordship.
This has gone to outside the state.
Your lordship. And all the details, your lordship, on the last occasion, I have submitted the.
This motorcycle is.
You can go for it. Yes.
And on the last occasion, I have submitted the taxi budget report listing with the assessment order.
Vehicle. Equipment, that battery was more fast. Like nano.
Yes.
And also particularly in this petitioner's case, only one document I have. Your lordship may kindly look into one vehicle.
That is in the Jharkhand.
One vehicle, not valid number. And waybill has been received, waybill has been generated and supplied. And only one point I can
We understand what your entire endeavor
100
is.
kilometers within half an hour. The petitioner has enclosed the documents I have found from here.
What?
100 kilometers within half an hour, another you will generate for another 18 kilometers.
Yes.
So all this, your lordship.
Yes.
What I'm submitting is that they have relying upon certain documents. So if they give me those documents,
Not required. This is a fact-finding authority is there. Go and file an appeal. The appellate authority is the last fact-finding authority. You can vegetate all these points. Let them decide and place all the facts there. Yes.
file that appeal.
Yes, fine. Yes. It will be fine. Yes.
Both the cases. Item 32.
Notice on it, done. Yes, please.
Your lordship, in this matter, I seek the permission to withdraw this matter with the liberty to file a better petition. While preparing for the matter, it has come to our notice that some points has not been considered.
While yes.
Item 34.
33?
33 gone with that item number.
Okay. Yes, yes.
34.
Have you checked both the matters?
Yes, we'll both the matters.
Yes, both the matters.
Today morning, item 3 asked over at 2 p.m. That's item 3 to ask from the bar the name of the advocate.
But
Item 3.
yes. Mr. Linka or something.
Yeah, Mr. Linka.
Yes.
Most of the advocate, it informs after that.
Mr. Lekha, is you not associate of Mr.
Item number 35.
Yes.
United. I am representing appellant. Which OP number 4, an employee of the bank, Kotak Central Cooperative Bank.
What are these several IAs? What are their?
These are all have been disposed of. One for dispensation of certified copy, which was.
Which one?
Certified copy of order of.
And
Item number
1096.
605, certified copy that was dispensed with, certified copy already filed in the meantime.
So there is no order or order has been passed.
Since it was already filed, so no order was. And IA number 606, 2025, there was delay and.
So that has already been condoned.
Yes.
Yes. And 607?
607 for appropriate orders.
Appropriate order. Now, what is the ultimate decision which is taken by the single bench?
He confirmed the order passed by Learned Appellate Authority, that's PG Act.
Yes. Then what is the ground?
I have relied on.
You have been given a notice?
Yes, ma'am. I have actually gone through respondent number 4.
You are the writ petitioner?
No, my lord.
No, he is the writ petitioner, sorry.
I have the.
You are the employee.
Yes, ma'am.
Yes, he is repeating that.
So what do you say?
This one opposite, but respondent number 4 has retired on super.
That is, I understand what regarding his submissions. But tell me the points, what you want to.
She stood as guarantor for 2 loans.
Two?
2 loans.
Okay.
So, and she has, after retirement, we intimated him through notice, and she has submitted undertaking that till that amount is not realized. So on that basis, we have not released the gratuity amount.
Can you, under the law, withhold?
I am citing to judgment of Punjab Exchange Bank, Labour Commissioner order, where recovery from outstanding loan was upheld. Recovery of outstanding loan.
No, recovery, he stood as a guarantor or she stood as a guarantor, whatever, in respect of a loan given to somebody else, not to her. Correct? Now she has attained the superannuation. If there is any default, have you taken any steps against that particular person to realize?
We have also
borrower, have you taken any steps against the borrower?
Yes, I have. We have issued notice to the borrower and.
Have you realized the amount from the borrower?
Still outstanding, and that these loans have become NPA and add to the loss of the bank.
There is a security placed along with at the time of disbursing the loan.
She stood at security. She stood at security.
Not security, sir. She is a guarantor. She is a guarantor. I am talking about when you extend the loan, there is any collateral security which you have taken?
No.
Then what bank you are? On what basis you have given?
Loan, 2 lakh loan and 1 lakh loan.
And what is the total amount which she is entitled as a gratuity?
5 lakhs. 5
So
5 lakhs
So-
74, and out guarantee amount is 7 lakhs 44.
So you will withhold every amount.
There is no rule under PG Act to withhold the gratuity.
Your case stands at page 63. Admittedly, the opposite party number 4's services were never terminated
Since
for causing any damage or loss to the bank. Rather, she was allowed to retire from service with effect from 31/7/2010.
Only thing is, suppose if she is a guarantor, then under the civil law, it is I'll say right is coextensive. You can sue both the borrower and the guarantor. You can sue either of the guarantor or a borrower, whatever is your choice. That is in relation to a recovery. But can you withhold this statutory amount, retirement benefits?
We can only when the loss is.
There must be some provision under the Payments of Gratuity Act. Under what circumstances one can withhold the gratuity.
That is provision.
Section 4 clause 6.
Section 4 clause 6. Only when
Only
service is terminated.
Then
loss is.
it is not a case of a termination because the judge has held that you have not terminated, rather you allowed her to retire.
Para 36, page 62.
It was 62
That provision is quoted and the portion is highlighted.
Yes.
So notwithstanding anything contained in subsection 1, the gratuity of an employee whose services have been terminated for any act, willful omission or negligence causing any damage or loss to or destruction of property belonging to the employer shall be forfeited to the extent of the damage or loss so caused. This is the provision which learned single judge has relied upon and rendered his finding in para 36 subpara. Right? So how to overcome this finding vis-a-vis this provision of
My humble submission is by guarantee and guarantee liability, already loss has been inflicted to the institution, to the bank. When a loan becomes NPA, so it is treated as net loss to the bank. Only thing, bank has not terminated her services. But admittedly, there is loss to the bank.
So,
the opposite party 4 is saying that she has already paid the amount, but bank is not giving her clearance.
where is the evidence?
No, but that is the problem. We don't have evidence. At least it is out of the box.
I checked today itself, the loan are still outstanding.
On the Payment of Gratuity Act, section 13. Protection of gratuity. Payment of Gratuity Act, section 13. No gratuity payable under this act and no gratuity payable to an employee. Employed in any establishment, factory, mine, oil plant, plantation, port, railway, or shop, except exempted under section 5, shall be liable to attachment in execution of any decree or order of any civil, revenue, or criminal.
Look at it. How can it be?
And also section 14 gives override effect of any other enactments.
Yes, sir.
Provision emphasizes an employee, even not an because of
Can you, sir?
Even I was holding a CPC with me. Section 60 of the Code of Civil Procedure also says that what cannot be attached in execution of a decree, which talks about the gratuity, provident fund, and everything is given, cannot be attached. If you cannot attach it, can you withhold it? What? So how can it? It has nothing to do, sir.
The loan outstanding,
That will sue her.
Sir,
on the basis of the.
sir, you are a legal expert. What is expected from you is that you will argue law, not the sentiments of your client. Tell us what is the power which is given to the employer to withhold the gratuity admissible to a retired employee whose services were not terminated, nor he was prosecuted or something of that kind. Tell us nothing. Can you?
Law is very clear about the.
Then what remains?
Power of the employee.
Nothing. Nothing.
Only.
Nothing. Nako.
Yes. Tell me. Yes.
Monday?
Whatever time you want, we will give you. But you'll have to hurry.
After vacation. After vacation.
Give an undertaking. We will not forget. We remember. Why not before the vacation? What is the difficulty before vacation? Have a weekend, take a weekend, full weekend, you utilize the weekend and prepare yourself. Yes.
After vacation.
No after vacation. No after vacation. No after vacation.
It is an institution. It is an institution.
What institution?
Yeah.
Yes, we are keeping this matter on next Wednesday. Come ready. And give. Give. Give.
They call the next.
Huh?
Item 37.
Informed by Union Archaeman will be again and informed by the office that Yes, this one I'm informed by office of senior Archaeman. There is only next one Passover is requested me to meet your lordships.
Anyhow, this is the exception because there is no adjournment for
Well, item 38.
This is that matter, the jurisdiction of Odisha Education Tribunal, whether it is attracted to this case or not, that was the issue. Last occasion we submitted some decisions, including the decision judgment rendered by Madam Justice relating to the punctuation.
Some senior counsel.
Yes, Mr. M.S.RAMAN was assisting the lordship.
The lordship will be available tomorrow if his views are
There, and there, they had.
He was sitting, we noticed that he was taking over since long time.
He just got a call, he had to rush back.
We are keeping this matter on Monday. He is okay to because we wanted this decision because it has a larger impact on all.
He had personally requested me, if matter can be, if a lordship request
tomorrow-
presence, he may be prayer.
maybe present to tomorrow.
Tomorrow also is ready to act.
Available.
Tomorrow also?
Tomorrow.
Yes.
Tomorrow.
Well. Item 39.
This matter is a tender matter. Fact, where lordship had filed an interim application so that they don't proceed, and on their oral direction, they had in fact not proceeded. But I think the I feel the lordship can be disposed of. May I permit it to? Yes. This matter.
This matter is assigned to Mrs. Patnaik, say some difficulties for that she had left. Can it be taken up tomorrow?
I'm already under the gun, always.
The direct of being thrown out of the participation. What to do?
And can it be taken tomorrow?
Make it tomorrow. She was here from my morning. No, tomorrow.
Well. Item 40.
Item 40, the time will be granted. And two is that questions, UTAPL number 46 may be added back.
Not sure this is, I'm not objecting to what my learned senior is submitting, this is that the matter which your lordships have already disposed of. Your lordship's judgment dated 6/8/2025 or in the same petition responses. It is that WNT DMT matter. Yes, DMT, covered matter, yes. Yes.
I have not received the position of the department because of the panel is ready.
Yes, I'm not objecting to that, I'm just recording your lordship's. Yes, Monday.
No, because the total panel has been. Yes,
I have not received, supposed to receive a copy, he can give you a copy right now.
On that.
Yes, give him a copy. I'll come on Monday.
Raises the same issue, similar issues. Different parties.
Yes,
So, first matter, my lord have with a different combination. Thereafter, this order.
I will go to them and on Monday.
It is in this case only.
Yes. Yes, no.
Item 41.
There's another OTAPL. This is 45, 47, 61. These are listed in the in the
46.
There is another 46 also.
I have to two times.
Well, yes, along with that. Item 41. Along with that.
I have the instruction to accept my lord because.
Yes. Which one of the judge?
41.
41 my lord. Will.
It is their picture, I understand, but he has not received.
So give him a copy. Yes. Write the matter so that on Monday.
We'll do. We'll call.
Because of position. So he cannot get.
We'll do the needful. Break. Yes.
41, sir. 41.
41, my lord, same prayer, my lord.
Well.
One small detail. Item 41 will be listed along with these appeals which are pending of the same issue. One of these.
Those are already listed. The wet metric ton and the dry metric ton matter.
Yes, ma'am.
So these are already listed. Right?
Possibly these are also connected matters.
There's more than new matters.
Then you have to serve. I will give her a copy.
Lordship, in those matters, sir, I was the respondent. He has to give me a copy. Department has.
My lord, because my lord.
Oh, you are for the department.
Department, but my lord, due to the copy is not with me, my lord, right now. My lord. I will
Soft copy is here.
My lord, I will.
District.
Same day.
We are newly inducted in the panel.
No, no, that-
Not in the panel, my lord. I will.
Well,
We will submit.
Order of the judgment is also served.
It's on the next.
Item 42.
42 my lord, I had filed again. They have not submitted copy.
Why?
Long chief, it was the.
My lord will give a copy. I will give a copy to the associate of.
You, sir, so complacent that you can't serve in course of the day or by tomorrow, Monday. Then the matter will be listed in the after vacation.
My lord will serve it in course of the day, my lord. To the associate of
By
my lord.
Monday, I will serve a copy of the.
Took a good time to show you.
Service to him.
My lord.
He appears and submit that he has instructed to appear on behalf of the respondent and place for service of the copy of the. Yes.
May people, on behalf of SL Patnaik for Statutory Commission, Statutory Commission, out of session.
Is for?
This is out of session.
Such consideration.
Which appellant or respondent who are. Appellant.
I am for the sole respondent, your lordship, have appeared. By Mali Makat, now let him serve the copy of the writ appeal as well as.
Matter after vacation is yes.
Well. Item 44. Yes. 44.
With due respect, I may be permitted to submit my representation. Sir, I am feeling nervous.
You have an advocate.
I had an advocate, but they.
You cancel the Wakalatnama, have you taken back the Wakalatnama from him?
No, sir, they have no contact with me. They have no response with me. So they disputed me really. So I gave an representation to DR, sir, to allow me to submit it.
Cannot be done. Have you canceled the Wakalatnama?
They are not responding me by several phone calls and WhatsApp messages. So what can I do, sir? 2 years left, 2 years gone.
Oh, I understand.
The petition has written a letter.
Yeah, the procedure is that if the litigant want to appear in person in a matter where he or she has engaged an advocate and he is not giving an objection, then in that event, she has to make out an application for seeking a prayer, seeking for cancellation of the Wakalat. That can be cancelled by the court immediately, and then permit the petitioner court.
He has written an application that is a flag M.S.RAMAN.
I have understood. Oh, you want it? Yes. Yes. We can allow. There is no difficulty. Flag it. This is an application written out by the people that.
That I may perhaps I protect the towering and ancient year-old heritage trees who are sacrificed forcefully sacrificed, who are speechless, and but every report is went rain. So the honorable court issued notice to the opposite party, but despite the notice, all the entire affected trees.
Madam, what is the issue you have raised in this petition?
The felling of trees without any reason and without following the law and without the.
So you are flagging an issue that the government is not taking any action with regard to the falling of the trees.
Sir.
That is what you have reversed.
Sir, I wrote to the every authority, the collector and DFO and the superintending engineer.
That felling of the tree or cutting the tree or something
Cutting of
an
the
imbalance in the ecological system. And
sir, without following the law and
may aggravate the global warming.
many things more, sir. Besides global warming, many things more also there. Many more
Vegetation, the survival of the birds, all these things.
or many things or more.
Or more, what?
Sir, I am a Gabra Siddha also. So in Ayurveda, it is written that after 100 years of the trees, they can be used as medicinal purposes. The age of this
all the trees.
Sir,
All the trees.
all the big trees, sir. They have
And a banyan tree.
yes.
banyan tree also used in smaller age, but it can be medicinal perfectly used. The medicinal value is perfectly developed after 100 years because 1/3 of the lifetime of the plant is required to be valuable for useful for medicine in Ayurveda. So the age limit of these large trees are approximate 300 to 400 years minimum. Minimum. So 1/3 of their lifetime means 100 years. They have got the trees in the excuse. They are showing that 100 years lifetime rotation. 100. Their lifetime is more than 400 years. Lifetime rotation after 100 years, they can survive more than 400 or more than that. So this is not their limited lifetime. 100 years is the lifetime of human beings.
Because there must be some kind of a guideline, there must be some kind of a.
Sir, something more, some more points are there, sir.
Oh. No, I got your paragraph 4. No, I've seen paragraph 3 and paragraph 4. So you have the trees which are of a very small duration. I mean, the lifespan is small, but they are ranging between 1 to 5 years. What?
That has been mentioned in paragraph number 6, Miller. Because we are saying that those trees may over 100 years, and the technical term used is that their physical rotation is up to that 100 years. So they do not have their lifespan is now after 100 years, it gets limited. So we have purposefully chosen those trees.
Nowadays, the technology has developed where you can uproot the the one and can replant somewhere else.
That was the
with the same, with the same, the lifespan.
That also because we have answered in paragraph number 5. They say that because these trees are so huge and because they've been there for 100 years, their roots have become a problem so far as shifting them is concerned. But crop root systems.
These trees roughly after fell for the purpose of widening the road.
Widening the road, Milord, as I gather from the counter affidavit, although it is not being specified neither in the invitation nor in the counter.
What is the statutory norms which you have done about felling of the trees?
Guidelines are there.
Forest department,
Yes, those are required.
I think the standard operating procedures are also there, guidelines are there, rules are there.
They are there, Milord.
No,
But
you
Milord,
have not disclosed anything.
No, Milord, that is silent and they have not annexed the guidelines. But guidelines are there, Milord, I am aware of.
Sir, no proof we have submitted and they have double counting the funding, sir. They are showing in the counter that they have done afforestation.
They are going by the numerical number or statistics that I have felled 1,400 trees and planted 7,900 trees. So they have gone by that.
But there is no proof.
What could be the proof?
Sir, geotag, photographing and the particular area location where they have planted, nothing is there. Sir, around the Burla town, this petition is concerned with Burla town. They are showing the plantation of.
They must have planted the trees along the side of the roads.
No, sir.
Give a
Nowhere plantation is done.
shed.
We have mentioned that in paragraph 4, Milord, from Chosfoot Bridge to Ghanteshwari Temple Road, Milord, 1,700 bara trees and.
Sir, Jaipur and Ghanteshwari is 30 kilometers far from Bulla town. And the people of the city They cannot expected to go there to inhale fresh air beyond the city and out of their home. Sir, this is related to Bulla town, my town, sir. And they have misleading the code that they are doing plantation. This is different, sir. And this plantation is coming under another scheme. They have another funding for that. They are coming under Banikaran or something, the felling of trees of that area.
Oh, yeah, they shaped the way. Now they have to come up with this law for the guidelines. Do you have the statutory provisions? Because there are statutory provisions in place that if they want to uproot any trees, then what is the required to be adhered?
Sir,
What is required to be followed?
Sir.
What they should take care of?
Sir, public
Thing has been given.
Sir, public hearing, Jonasunani, and transplantation feasibility test, sir, or and another is
Where are those?
sir, transplantation feasibility test is there. Where these are sir implemented in the other areas of this country also. And I have contacted to the agency of transplantation also personally, and they have their provisions 70,000 in exchange of my personal transplantation. I have contacted for that, and they sir, 1 minute, sir, excuse me. Just a minute. There is an agency I have contacted, and there is they are doing their transplantation work, but they never done anything. They never tried and never followed the due process. And
There is one or two judgment of the Supreme Court on the.
Sir, Supreme Court, there are the M.C. Mehta and Union of India precautionary principle mandated by Honorable Supreme Court.
Yes.
And another is, sir, here is also a order. Another order is there, sir. I have a here. Sir, the TN Gadaparman, Tirumupulad and Union versus Union of India. There is a strict compliance of Forest Act is required for before felling the trees. So Rafa Junior Mining, this is versus Union of India. Indian Council for Environment Legal Action versus Union of India. MC Mehta and Kamal Nath and Subhash Kumar versus State of Bihar. Sir, MC Mehta.
Judgments was that particular, the citation, because those judgments have already mandated what is required and what is not required.
Sir.
So in your matter also, they have to follow that particular law which is laid down in the Supreme Court.
Sir.
They cannot do something which is wrong.
Sir.
So there will be an omnibus order to be passed so that whatever the compensation which they are required to do, they have to do a compensation if at all found to have violated. And in the future, they have to follow that mandate of those judgments. That what are the Forest Act says, what are the rules says, what are the SOP says, all these things have to be followed by them.
Sir.
So give those line of judgments, give this reference which is talking about, because I am aware of two judgments there must be one of them is MC Mehta's judgment. Where and I believe in 2023 or 2024, there is also a judgment rendered by the Supreme Court. Overalling that particular level, how the plants, felling of the trees, cutting of the trees in the garb of an urbanization or the development. Suppose the Supreme Court has also said that certain safety measures have to be taken in this regard. Give me those rights.
Sir, they are misleading the code by giving false counter that they have planted, but they have not planted.
You come that they have not planted this. You give an evidence.
Sir, I'll give. Sir, where they planted? No,
They have said
planted.
there are two things. One, you are saying that you belong to a particular area, And therefore, if the trees are uprooted in that area, the plantation must be done in that area. But they have said that, yes, I have done a plantation in this area, which according to you is far away.
Far away and another scheme coming under another.
That shows that they are not telling a lie. Only thing is, they are not coming up to your expectation. Your expectation is that everything should be at the doorstep.
No, sir, the replacement is
So we
replacement.
have to consider this, how far that can be done. Let us see.
And the funding, sir, whatever these are different funding, and this funding for felling of trees is given by the PWD. They have mentioned 2 lakh something 56,000, and that plantation was coming under another funding, and the sampling distribution is coming under Banikama scheme, and the funding they are double counting the money funding and mix up the funding here and there.
We consider. Let us see for the law. Let us consider the law. Thereafter, we'll consider what is there. When you come before the court, you should show the law, that what is the law. If they have violated the law, definitely they are liable to consequences provided in the law. We have to see from the overall scenario, because the Supreme Court has also come up with many of the guidelines or the directions that has to be followed. The forest under no circumstances should be compromised. The forest land, it has to remain. And if you have done it, having that event, something is good.
Sir, without survival statistics and judgment of Supreme Court, without survival
What is the
statistics.
judgment? What was the judgment of Supreme Court?
Sir, I will show in the next date, sir. I am.
If that's why I said to him, because you are not having all those journals. Give him the names. He will find out from the journals. Book would be immediately be placed before us. Don't worry.
Sir.
When can we?
Well, sir, as per my convenience.
Give those compilation on the environment issue. You will not do. You'll have to bring that text, the book, authenticated.
Okay.
Ayurveda's book must be in Sanskrit with the full translation of. I want Sanskrit.
Right, for the transaction, sir. I have Hindi version.
Come with the version of both English, Hindi,
Right, I will search.
Oriya. Let us see that the translation is correct or not.
So I will try for Sanskrit first. I have Hindi version, Hindi translation.
No, it has to be original text we want.
Sir.
And then the translated book. Yes. You just bring, we are keeping one day because we are running short of the vacation. So we are keeping this matter on 14. Keep it on 14, we'll hear out this matter first.
14th October.
Yes, we'll hear out this matter first.
Keep it to 15th or 16th July because just after the reopening,
Just after reopening, you are having 5 days, not reopening.
Second week, Milos.
This is a very important one.
Milos.
And Mr. Roth, yes, sir. We wanted to appoint you as an amicus in the matter. Environmental issue. You have been championing the cause for many, so champion the call for us.
I'll try to reach out to my Lord Secretary.
Just I was held up in the lift, so it was just pass one pass over was.
It will appear on Monday.